a status conference calendar. It's my understanding that all of these cases have appeared on the calendar before. Most of them are represented by counsel. I previously rescheduled these cases so that counsel either would have a chance to engage in discovery, which I hope most of the cases have been done by now, and for you all to decide whether you're going to accept the offer of the state or whether we're going to proceed to a bench or a jury trial. So let me call the calendar to see where we are this morning. Position number 1, Charles Bass.
Good morning, Your Honor. Mr. Davis present, representing Mr. Bass, who is also present. Discovery has been satisfied on this case. I would like to conference with the state.
Okay, good morning, Mr. Davis. We'll give you that opportunity. Thank you.
Thank you.
Position number 2, Justin Chapman. Justin Chapman is represented by Kevin Fisher. Mr. Chapman or Mr. Fisher present? Okay, that's my understanding that Mr. Fisher is going to join us in time. He's he contacted the court apparently and let us know that he was going to be late.
Got it.
I'll hold for announcement. Thank you, Ms. Falk. Position number 3, Albert Claremont.
Good morning, Your Honor. Attorney Gabe Winters for Mr. Claremont.
Good morning, Mr. Winters. What are we doing with Mr. Claremont this morning?
Judge, I'm still waiting for discovery on this case. Unless it was put in the mail recently, I still have not received anything.
Well, let me inquire. Have you done e-filing?
Yes, everything's filed.
Okay. Let me just double check with our person who handles the e-filing to make sure that that has been uploaded to our system.
Okay. I'm going to hold for the announcement on
Yes, Your
position.
Honor. Thank you.
And just let me tell you what my expectation is. My expectation is that once I reset a case for a status conference, especially if it has to do with discovery, that if there's an issue with discovery, I expect that at least prior to the hearing date that's scheduled, that you contact the solicitor's office to try to work out any problems in regards to that discovery. If there are problems, then you all can let me know, but I'm trying to move these cases forward as quickly as possible. And I give a reset most of the time so that you can engage in discovery. But what I expect is that once I do give that reset, that you will help the court by moving these cases forward. Position number 4, Tavo Dragony.
Good morning, Your Honor. We're asking for a conference with the state this morning.
Okay, good morning, Ms. Scott. Position number 5, Harrison Fuller. Harrison Fuller, represented by Lindsay.
Good morning, Your Honor. Courtney Brubaker on behalf of Mr. Fuller. Miss Lindsay Haney is an associate at our firm. She is out today, so I am covering for her, Your Honor. We have filed a waiver and wanted to ensure that that waiver has been received by the court.
Okay, let's see. And do you have the ability to be on camera with me?
I'm trying right now, Your Honor. My camera let me see if I can make that work. There we are. I apologize, Your Honor.
No, you're fine. I just it's hard for me to find people when I can't see them.
Yes, absolutely. I understand that.
Okay.
And perhaps I'm misreading the notes. I'm seeing in the notes that this was reset to this calendar because a waiver was filed for the December 9th calendar.
Okay. Do you know, Ms. Brubaker, have you received all the discovery in the matter?
Your Honor, let me switch screens for a moment and check with my file. We had filed a waiver in a jury trial demand. So I don't know if that makes a difference. I do not see where any discovery has been received, Your Honor.
All right, so the way what I normally do is the first time the case is on the calendar, if it's necessary to reschedule it for a status conference, I will do that so that to give you all an opportunity to best represent your clients, get all the discovery, talk to the state. Once it gets on a status conference calendar, my next move is either to set it for a bench trial or a jury trial. Since your client, you and your client have demanded a jury trial, we're going to place you on the jury trial calendar. Which is not set yet, but it's going to be on the March jury trial calendar, okay?
March, yes, Your Honor.
And so what I'm going to expect is that if there's going to be a plea before that time, that plea be arranged with the solicitor's office, and we will put it on a final plea calendar. If the case does not plead out by the March trial calendar, I'll expect that you will be ready for trial in March, okay?
Yes, Your Honor. Thank you.
You're
Your
welcome.
Honor, if we may go back briefly to position 4, Albert Claremont.
Okay, let me finish up with position 5.
Yes, Your Honor.
So Ms. Brubaker, anything further for the court this morning?
No, Your Honor, that is my only case, so we will look for that notice, and may I be excused?
Yes, have a good day. Thank you.
Thank you. You too. Take care.
You do the same.
Thank you.
Yes, Ms. Falk,
Didn't mean to
position
jump the
4.
gun there, Your Honor. Albert Claremont, we are showing in Odyssey in the clerk side that discovery was filed by our office on December 3rd. So I'm not sure why it has not been received by the defense, but I verified that it was in fact served on the defense via e-discovery on December 3rd.
In what case is that? I'm sorry.
That is on Albert Claremont, position 4.
Mr. Claremont, Mr. Winters, did you hear that?
Yes. I guess what my discovery, so I was speaking to, I'm sorry, another solicitor from their office, and I had asked for a more complete report and a copy of the video.
Okay.
Discovery is very minimal. It's just basically a ticket. And so I was asking for further discovery, and the solicitor that I was talking to said she would look for it and get back to me. And I've not received anything further.
Okay.
And
So,
actually, Your Honor, that's incorrect. I just looked at the discovery. It is also a police report. And just for everyone's edification, my name is Shelley Falk. I am handling the racing calendars from here on out. So if there's someone you need to speak to within the Solicitor General's office, again, my name is Shelley Falk, and you can speak with me. I will put my email in the chat so that you have contact directly with me.
okay. So, Mr. Winters, I'm going to allow you to speak with Ms. Falk this morning to make sure that you have everything you need, or we'll be able to get everything you need, okay?
Thank you, Your Honor.
You're welcome. Position 6, Brian Harris. Brian Harris, who is represented by Kimberly Berry.
Can you hear me? Can you hear me, Your Honor?
Yes. Good morning, Mr.
I
Harris.
know. Good morning. My lawyer's on the way. I know she's got booked into a case, and then her other lawyer is going to be handling this morning.
Okay, I'm going to hold for your announcement. Thank you, Mr. Harris.
Okay, no problem.
Position number 7, Stephen Hicks. Let's see. It appears that Melvin Nash has a leave of absence that's active through the 26th. So we're going to reset this till the next status conference calendar. That calendar is going to be on March 1st at 9 a.m. Position 8, Timothy Horn.
Mr. Horn is present. I received an email yesterday that was also, I believe, sent to the clerk's office stating he has a conflict. He has several cases, and I cannot remember the county for the life of me, but he has, thank you, Walton County. He had several cases in Walton County. That is Mr. Horn. He had several cases in Walton County that he needed to address first. So we are holding, I have given him my phone number so he can get in contact with me and let me know when he will be available, or even if he will be available today.
Okay. Good morning, Mr. Horn. I'm doing fine, thank you, sir. We will hold for Mr. Winfrey's report, okay? So you just sit tight for us. Thank you, sir. Position 9, Demetrius Johnson.
Good morning, Your Honor. I see Mr. Johnson on the Zoom call. Mike Maloof, filling in for Mr. Pack today. If I could pre-try the case with Ms. Falk, we filed for discovery in December. He filed. I don't see it in the file, so I'll speak with her to see if we can reconcile that and report back to the court.
Okay, good morning, Mr. Maloof. Are we here in this case?
No, Your Honor, my client has a similar name. It's Jamal Demetrius Johnson. And
Okay.
Same confusion happened last time. So I was just about to leap up.
Okay, you're the next case. All right.
Okay.
And looking at the e-file system,
No. Hold on. Actually, this is Mr. Pack's case. Position number 9. Apparently, yes, we have a Jamal Demetrius Johnson. That's position number 10, Mr. Maloof. And this is position number 9, Demetrius Johnson,
Yes.
who's represented by Mr. Pack.
Mr. Kimbrell.
Mr. Kimbrell?
Yeah, Jamal Demetrius Johnson is my client.
right, we're on number 9, Demetrius Johnson.
Yes.
Okay.
I apologize for the confusion, Your Honor.
So position number 9, Demetrius Johnson, I have it represented by Mr. Pack, and Mr. Maloof is going to wants to speak with the solicitor in regards to that case. Is that correct?
That is.
And I just want to put on the record, we served our discovery on November 27th, 2022. That was before they entered their appearance, so they will have to pay for the discovery through the clerk's office.
Okay. So Mr. Maloof, in turn, I will let you speak with Ms. Falk, okay?
I will. Thank you, Judge.
All right, thank you, sir. Okay, now Jamal Demetrius Johnson.
Good morning, Your Honor. Clayton Kimbrell for Jamal Demetrius Johnson. I filed a discovery motion and or demand in the clerk's office, and they stated that next time to e-file it, that it would be okay if I went ahead and filed it in the clerk's office. And then I took it to the solicitor's office. The clerk in there said the same thing. Don't worry about e-filing. We got it in the system. She file stamped it. I went on my way. Last time I was here, I spoke with Mr. Rhodes. He stated that he would reach out to me regarding the video because my client has a possible justification affirmative defense. And but I have not heard from Mr. Rhodes. I haven't received discovery as of today.
Okay.
Okay.
Again, with the exception of the video, the discovery was filed on December 5th of 2022. That was 2 days before the entry of appearance, and he would have to pay for that discovery through the clerk's office. That is not something our office controls. But I will find out about the video today before Mr. Kimbrell leaves.
Okay. So speak with Ms. Falk.
Okay.
I'm going to reset you for the status calendar on March 1st. Do you think that'll give you enough time to do everything that you need to do to get the case prepared?
Yes, Your Honor, that should be enough time to obtain the video, which is crucial, and all the other discovery, I would imagine.
Okay.
And I'll speak with Ms. Falk as well
Okay.
today.
March 1st at 9 a.m., Mr. Kimbrell.
Thank you, Your Honor.
You're welcome. Position 11, Michael Cosgrove. Kozrev,
Yes, Harold Johnson here for Mr. Cosgrove, Michael Cosgrove.
Yes, good morning, Mr. Johnson. What are we going to do with your client today?
Sorry, I couldn't hear you.
What are we doing with your client today?
He's in the military and he's currently on the leave. And so if we could continue until he's able to come back from the military.
Okay, is there an expectation as to when he'll be able to come back?
We're trying to figure that out right now. We do not know when he's able to come back, but we will definitely let the court know once we know.
Okay, I'm just inquiring because, I mean, I don't want to keep putting this on a calendar month to month if he's not going to be back for, the young lady has her hand up here.
Yeah, I'm his stepmother.
Okay,
He has, he's graduating from boot camp on February 3rd, and he has orders for his accession school. That school, his orders are through September 14th. And when I go for the graduation ceremony, I'll get the actual copy of those orders. I can't get them before. So after the A school, he'll have C school. So I know he won't be able to come back until at least after September 14th.
okay. Ms. Falk,
If we can be provided some sort of written proof of that, I have no objection to having this continued until September. I mean, I can't produce somebody who isn't available.
right,
So-
right. Okay, so, can we get Ms. Falk, an indication of what you said, ma'am?
Right, a copy of order should suffice, Your Honor.
Okay,
Yeah, I returned from that trip on February 5th, so I should be able to provide that through council.
Can speak on this? Sure. That way you can just send it to me. And Your Honor, I'm just giving Mr. Johnson my email address so that he can email me the paperwork, at which point I'll reach out to Ms. Redden and let her know.
thank you.
Thank you.
Thank
So
you, Your Honor.
we're just gonna reset this further notice. Okay,
Yes, Your Honor, and I'll get that information hopefully in early February and communicate that to Ms. Redden.
okay, thank you. Anything further, Mr. Johnson?
Nothing further, Your Honor.
All right, you all have a good day.
Thank you.
Position 13, Henry Rivas, RIVAS.
Good morning, Your Honor. Tom Mitchell on the Zoom.
Good morning, Mr. Mitchell. Mr. Rivas is in court with me this morning. What are we doing with him today?
That's true, Your Honor. Mr. Rivas is there. I was trying to get, so this gentleman has another case, and we were trying to get the two cases put together to resolve them as one. And I was trying to get with Ms. Falk on that.
Okay, yes, he's in position 12 and 13 I have.
Oh, good. Okay, good.
Yes,
So
they're
that
both-
much got done.
Yes, that much got done. So I'll give you the opportunity to speak with Ms. Falk this morning while Mr. Rivas is with us, okay?
Okay, thank you, Your Honor.
You're welcome. Position 14.
I'm gonna hand over this, Mr. Rivas.
Oh, okay. Yes, Mr. Rivas, we'll be with you, sir. You can-
Okay.
Thank you. Position 14, Allison Montgomery.
Good morning, Judge. That's my case. And just based on some of the dialogue I've heard prior to, we did receive discovery, some discovery on December 5th, but it appears we need to get the video from the clerk as well as continue negotiations with Ms. Falk. So we would please just ask for a one-time continuance, maybe to that March 1st status calendar if possible.
Ms. Falk.
State has no objection in this to the request. And we will check on the video and the status of that.
Okay. This will actually be the second reset of the case. With that noted, please, we'll reset this to the March 1st status conference calendar. I expect on that calendar that all discovery will have been obtained and that either there's going to be a plea in the case or we're going to place it on a jury or bench trial calendar, okay?
Yes, Judge.
All right. Anything further this morning?
No, Judge. May I be excused?
Have a good day. Thank you.
Well.
Position 15, Ponarv Nara Tarnan.
Good morning, Judge.
Yes, good morning.
So I'm represented by attorney Bridget Bray, but I'm not exactly sure where she is. Tried getting in touch with her, but it seems like she's not answering my calls or anything. So
Okay, are you on camera with me?
yes.
Sir? Oh, there you go. There you go. All right, so we're gonna try to raise your attorney, and I'm gonna hold for her announcement, okay?
And Your Honor, I do see a notice of conflict that was filed yesterday at 9:02 p.m. So that may be why Ms. Redden was not alerted to it, where she has listed that she has a number of conflicts, 3, I believe, prior to this case in Snellville Municipal Court and Atlanta Municipal Court. So that could be the reason for her delay.
Okay, I'll hold for her announcement.
Thank
Thank you,
you,
sir.
Your
If you'll just sit tight for the court.
All right, thank you.
You're welcome. Position 16, Lydell Northington.
Yes,
Hey,
sir.
hey, Judge, good morning. This is Attorney Kevin Fisher. I just hopped onto the Zoom. Thank you for waiting for me. I'm here on both Mr. Lydell Northington, Mr. Justin Chapman.
Okay, so let's start with Mr. Northington. What are we doing with him this morning?
I just need to finalize pretrial with the prosecutor, and then we can make an announcement to the court.
Okay.
And that'll be the same announcement for the other individual, Mr. Chapman.
And Mr. Chapman's position number 2. All right, I'll allow you to speak with Ms. Falk this morning.
Thank you.
Position 17, William Shirey.
Good morning, Your Honor. Alex Merritt on the Zoom. Is it Shirey? Shirey?
Yes, it's Shirey. Good morning, Mr. Merritt.
Good morning. I will just need a moment to speak with Ms. Falk. I think we can perhaps resolve the case today, but I do need to discuss the case with her briefly. So I have fashioned an email as she's requested, and I will, with the court's permission, speak with her and make an announcement after that.
Okay. And is it Shiley?
It's Shirey.
R-E-Y, okay.
And he is on the Zoom as well, Your Honor.
All right, thank you.
Thank you.
Position 18, Miles Tally.
Yes, Your Honor. Good morning, Attorney Evan Watson for Miles Tally. I'm sorry. Can you hear me, Your Honor? It looks like I froze up. Okay, thank you.
Yeah,
Judge.
you're fine, Mr. Watson. I can hear you.
Thank you, Your Honor. Your Honor, I likewise have kept open ears. So I think what the court wants to know is we have received discovery through the e-filing platform. We've received all the paper discovery through the e-filing platform. We also previously filed a waiver of arraignment with a jury trial. We're asking to stand on that. I heard the court's announcement about a potential March jury trial calendar, but we're asking to be placed on that calendar.
Okay, and I have you down for a Miles Tally and a Tyson Tally. Are those the same? Is that the same person?
No,
They're 2 different people?
they are 2 different individuals, Your Honor.
Okay, so Miles Tally, we're going to place him on the March trial calendar. And what about Tyson Tally?
I believe the same waiver. That it would be virtually the same announcement for the other Mr. Tally as well.
Okay. All right, you'll get notice for that March trial calendar, and if you do work it out or before that time, if you'll let Ms. Falk know, we'll get you on another calendar. If you don't work it out, we'll be expecting that you'll be ready to go in March, okay?
Yes, Your Honor, and I've taken note of Ms. Falk's contact information. I'm going to send her an email when we log off this morning as well.
All right, very good. Anything further this morning?
Not from the defense, Judge.
All right, you have a good day.
Thank you, Your Honor. You as well.
Thank you. Okay, let's see. Anyone on the Zoom or in court with me that did not hear their name? All right, so what I'm going to do now is the court will be in recess. I am going to have Ms. Falk get in touch with each of you, or you all get in. How would you like to do that, Ms. Falk?
Your Honor, I placed my email address and a request for them to send me emails in the chat in Zoom to everyone. So the attorneys who need to speak with me, I would appreciate if they would reach out that way because it's easier than doing the chat function in the Zoom.
Are they going to reach out to you by phone or?
They can reach out to me by email and I can respond by email right now.
Okay.
So,
you
or
think
by,
that you're going to need to speak with them in person?
I can also speak with them by person, so I'll put my phone number in there as well.
Okay, I'm trying to do this in some kind of organized way. Is why I'm asking, because if we go down the calendar, you take them one by one as we go down the calendar, then that would be preferable to the court, so we know where we are.
I understand.
So if that's good with everybody, then why don't we see if we can do it that way?
I just was concerned about multiple phone calls, which would make it harder for me to field than multiple emails.
Okay.
But I am more than happy to put my phone number in the chat as well, Your Honor.
Okay, so why don't we put your phone number in the chat? We're going to start off with position number 1, which is Charles Bass. So Mr. Davis, if you will give Ms. Falk a call regarding the case, and then we'll just move to the next case. So you're all going to have to be patient with the court as we only have one Ms. Falk that can talk at a time, okay? Counsel, I know that you're here in person, so maybe she can, as she's waiting, she can fit you in at some point, okay?
Understood, Your Honor. I appreciate it. Thank you.
Very good. Any questions before the?
Your Honor, so
Yes.
if we have not been reset, do we have to come back to court to be reset? This is Beatrice Scott for Tavo Dragony.
No, once you have your conference with Ms. Falk, I want you to make an announcement as to if an agreement was reached or if agreement was not reached. If an agreement was not reached, I want you to announce whether you want to be placed on a status conference calendar one more time, or whether you want to go straight to a bench or a jury trial.
Okay. All right, I'll talk to Ms. Falk.
Does that not make sense, Ms. Scott?
It does make sense. I do know probably at this point we won't reach an agreement, so I would ask to be put on another status calendar.
Okay.
One more time. This is my first time actually in court.
Okay. And it's this court's preference to move these cases as quickly as we can move them. So I'm encouraging you all to, as I said before, what I normally do is I normally have an arraignment calendar. At that arraignment calendar, quite often, counsel wants to be put on a status calendar because you have not received discovery. What I expect is that if you go from an arraignment calendar to a status calendar, then you're going to get all the discovery you need. You're going to be in contact with the solicitor. And when you come back for that status conference calendar, unless there's something out of the ordinary, I want you to be ready to either go forward with a plea, if that's the case, or go forward to a bench or a jury trial. Okay, I don't want to keep putting these cases back on a status calendar and just pushing them down the road. I want to give you the opportunity to properly represent your clients, but I want you to help the court move those cases forward, okay?
Yes, Your Honor, I certainly understand.
Okay.
Go
right,
ahead. I'm sorry. I didn't mean to interrupt.
No, go ahead.
On Mr. Dragony's case, I just responded to Ms. Scott's email. Discovery was served on December 2nd.
Okay, thank you. All right, so let's begin with position 1, Charles Bass. Mr. Davis, I guess, have you put your phone number in there?
I did, Your Honor, to Mr. Bass. So I'm working them one at a time, so that way I don't get multiple phone calls. So I have put my phone number in the message to Mr. Bass's attorney, Mr. Davis.
Okay.
And thank you, Judge. I'm calling Ms. Falk now.
Okay, very good. Thank you.
That way we'll know one by one, and she can just contact me.
That work for you, Ms. Falk?
I think I heard what you said. Yes, let me write down my number for you.
Yeah.
Yeah.
I'll have them give me their numbers and I'll go according
Oh,
to the
great.
calendar.
Okay.
And then that way, when you're finished with that one, I'll give you the next.
Wonderful. Can I give you?
Absolutely.
Yeah, let me write down.
Thank you. All right, so counsel, I have Ms. Monica Redding in court with me as a clerk today. If you will all go ahead and put your numbers in the chat to Ms. Redding. She'll have your number and Ms. Falk will call you all in turn, okay? Thank you. Unless there's anything further, court is in recess.
Thank you, Your Honor.
Did he say we on recess? Was recess?
Yes, sir.
Okay.
We're in a recess right now.
500 on the Just I sent him my phone number and I requested his and I haven't heard from him yet. Oh, thank you. So we'll just move on to the next one.
So is there an announcement on position one, Charles Bass?
Yes, there is. Mr. Davis has, we have spoken about a recommendation. However, there are some, it is contingent upon some information that Mr. Davis needs to provide the state. So he has, I believe Mr. Davis is still on the line.
Yes, he is.
So Mr. Davis has announced that the expiration date on this offer is February 10th. And he stated he will be in contact with me by then to either accept or reject the offer. But he has to provide me some additional information before he can accept the offer, essentially.
Okay, so should we put this on either final plea or status conference calendar, Mr. Davis?
Your Honor, I think we should put it on a jury trial calendar, because if we don't resolve it, that may be where we're heading next. So therefore, if we do not resolve this, I think that the best thing to do is just put it on a jury trial calendar. So that will be the next step. But if we do get it resolved, we can plea at that jury trial calendar call, if that's okay with Your Honor.
It's fine with me. So the March jury trial calendar. Is that good with everyone?
That is fine. However, Your Honor, just asking the court and Ms. Redden, if he does wish to accept the plea by February 10th, is it possible we can put it on an earlier calendar to get it resolved?
That's fine with me.
Okay, great. Thank
If
you.
counsel's available and you're available on one of my other calendars, then I'm happy to put it on before that jury trial calendar if it's going to be a plea.
I appreciate it. Thank you.
Okay. Anything further, Mr. Davis?
Your Honor, will we get a notice for the exact date and time?
Yes, you will. As soon as the court knows when that jury trial calendar is going to be in March, you'll get the notice. Okay.
Thank you, Judge. May we please be excused?
Yes. Have a good day. Thank you for your patience.
And we do have a notification on position 8, Timothy Horn. Mr. Horn has spoken to Mr. Winfrey. He has stated he will not be available due to the conflict to come into court. And so that was the announcement that I've received.
Okay, so we're going to place that on the March 1st, position number 8, Mr. Horn. Are you with me, Mr. Horn?
Yes, he's here.
Yes, good, Mr. Horn. Since your counsel's unavailable, we're going to reset you to the March 1st status calendar, okay? We appreciate you coming down here this morning. Thank you, sir. All right, anything further for me this morning, sir? Sir, you're good to go. Have a good day.
Judge, I responded to Ms. Falk on 2 of my cases.
And so I will call Mr. Fisher right now.
Thanks.
All right, thank you. Courts in recess until
Judge, if I could make an announcement.
Yes.
I work in the same office as Miss Berry. I will cover her Brian Harris case this morning. She wanted me to just announce ready for trial and ask that it be set on a jury trial calendar.
Okay, so Brian Harris is position number 6. It will be placed on the March jury trial calendar.
Thank you, Your Honor.
Is Mr. Harris on the line with us?
I am. I'm here.
Yes, Mr. Harris. You're free to go, and I will see you back in March.
Awesome. Thank you. Have a good day.
You do the same. Thank you. I appreciate that, Mr. Winters.
Yes, Your Honor.
Okay. Of course, in recess until Ms. Falk's available.
Tavo Dragony's case. I believe that is position 5. Nope, position 4.
Position 4. Okay,
I have spoken to Ms. Scott. I have emailed her the offer on this case. She is not, even though the discovery was filed, because she entered her appearance after it was filed, she has to get the discovery through the clerk's office. I am also going to email her a body worn camera that we have in evidence. And I'm holding the offer open until February 10th, and she has requested this be put on the March trial calendar. But like with Mr. Davis's case, if she accepts the offer, we would put it on a different calendar. We would ask for a reset to an earlier calendar to resolve it.
okay. Is Ms. Scott still on with us?
I am, Your Honor.
Okay.
Yes.
So again, we'll put it on the March trial calendar. If you are able to resolve it prior to that time and you want it placed on a different calendar for a plea, then we will do that. If not, I will expect that you and your client will be ready for trial in March, okay?
Yes, that's correct. Yes.
Very good. Anything further this morning, Ms. Scott?
No, thank you, Your Honor.
Thank you. You have a good day.
You too.
What about on position 2 and 16?
I have spoken to Mr. Fisher about both Justin Chapman and Mr. Northington's case. He is currently speaking to his client on Mr. Chapman's case to see if he wants to accept the recommended offer. And if he is prepared to go forward today on position 16, which is Mr. Northington, there is some documentation that I need to review that Mr. Fisher has asked me to review in possible mitigation.
Okay, so we will hope for announcements regarding that.
Yes, Your Honor.
What about position 3?
Position 3, my last information on this is that he was unavailable. Am I maybe reading that wrong?
Mr. Winters, are you there?
Yes.
Okay, and my understanding that you wanted to speak with Ms. Falk this morning?
Yes, I sent her email and I sent her my cell.
Okay.
So we'll
I
have
will
her get in touch with you next, Mr. Winters.
That
okay?
is the next person on my list.
All right, very good. All right, thank you.
which is position 3. I have spoken to the defense attorney. He has received the discovery, which was filed on December 3rd. He does want to see if there is some body worn camera. I have reached out to my investigator to see if we have any that I can provide. As of yet, I do not have any body worn camera, so it's not just a matter of me having it, not providing it. I don't have it at this time. And we're checking to see if it is available. If it is, I will provide that to Mr. Winters by the end of this week. And he has asked that this case be held open and placed on the next status calendar so that we can see if we can resolve this. And he's asked me to hold the offer open as well, which I will hold open. If I can get the body cam to him by the end of the week, the offer will be held open until February 10th.
Okay, so Mr. Winters, March 1st status conference calendar work for you?
Thank you for asking, Your Honor, and that works perfect.
Okay, so we will reschedule you for the March 1st status calendar. I hope that you all are able to, I hope that you're able to get all the discovery that you need by that time. If it's going to be a plea, Mr. Winters, if you will go ahead and make sure that you get from the solicitor all the paperwork that you need, so we can and have that already filled out so that we can move quickly through that plea. If it's not going to be a plea, we'll place it on that March trial calendar. Okay.
Yes, Your Honor.
Okay, any questions?
No, Your Honor, may I be excused?
Yes, have a good day. Thank you.
You too, Your Honor. Thank you. Thank you, Ms. Falk.
Thank you. Do we have the number for Mr. Brubaker, I believe was standing in for Miss Haney on Harrison Fuller?
What position?
That would be, let's make sure I have the right position.
Position 5.
That's gonna be position 5.
Okay, that was a jury trial demand. That's my
That's the
understanding.
jury trial demand. Thank you.
The next in line that I have is position 9 with Mr. Maloof.
All right.
Are you with me, Mr. Maloof?
I'm here, Judge.
Okay, I appreciate your patience. Ms. Falk will give you a call so that you all can discuss. Okay, thank you.
All right. Thank you, Judge.
So, Miss Position 9, Demetrius Johnson.
Yes, correct.
All right.
Spectating at it, you know.
And thank you, Mr. Kimball. You'll be next.
No problem, Your Honor. Thank
Okay,
you.
you're fine. Thank you.
I think so.
Okay, what is the announcement?
The defense is going over the offer with their client, and if he does accept the offer, they will enter a plea today. And I have also sent him the plea paperwork so he can fill it out and send it back to me.
Okay, very good. So, Mr. Miller, just let me know when you're ready.
Absolutely, Judge. It's actually Mr. Pack doing all this. I was filling in. He just got back from another court. So if he pops on, he'll be under my name, but we'll get this taken care of. Thank you.
Okay, very good. Thank you.
And I am now speaking with my one live human being.
Okay. All right, thank you.
10. I have spoken with Mr. Kimbrell. I've reached out to my investigator to see if there is a video. Again, the state does not have one in their possession, but just out of abundance of caution, I've reached out to ask that they check and see. Mr. Kimbrell has requested this be placed on a status calendar, and I have explained to him the offer that is on the table right now will expire February 10th.
The March 1st status, does that work for you, Mr.?
Yes, Your Honor.
Okay, 9 a.m. And if you do have a plea, if you can make sure that we have that ready to go so I can get you in and out as quickly as possible.
Understood.
Okay.
Thank you.
Anything further for you today?
No, Your Honor, may I be excused?
Yes, have a good day. Thank you.
Well,
Thank you.
And I am going to call the attorney for Mr. Arvia now.
Okay.
And Your Honor, one quick question. This is Mike Maloof. I apologize. Position 9 on Demetrius Johnson. I believe we have a plea for the court's consideration. I'm about to send the paperwork over. Can I sign on his behalf, Judge?
Yes, that's fine.
Okay, just want to make sure. He gave me permission. All right, we
Okay.
should be ready shortly. Thank you.
Okay, very good. Let me know when you're ready.
Thanks, Judge.
And I think Mr. Mitchell, you're next in line.
Okay, thank you, Your Honor. Commissioner Henry, Arvia Rivas, which is position 13 and, or, well, 12 and 13. The announcement is going to be from the defense attorney on this case, Mr. Mitchell. But the state's announcement is that I have sent a request to just check to see if there is an additional body cam or dash cam. The state's recommendation does include jail time, and so I believe Mr. Mitchell would need to speak with his client before accepting any kind of offer. We have put a deadline on the offer for February 10th, and I believe Mr. Mitchell would like the case reset to March 1st, but I feel that he could answer that better than I could.
Yes, Mr. Mitchell.
Unmute. Now can you hear me?
I can hear you now. Go ahead.
Okay, Honor, I think Solicitor Falk got it right. An offer's been extended because it involves jail time. I'm going to need to go over it with my client. She's checking on some videos. We're asking to be reset to the March 1 status, and we'll plea it at that point. Negotiate more, plea, or ask for a jury trial. We'll do that on March.
All right.
Okay.
So we set you to March 1st at 9 o'clock.
All right. And may my client's in the courtroom, may he be excused?
Yes.
And
so let me just make this clear for everyone, that if you do come back on March 1st and it is a plea, and that if that plea does involve jail time, that he is either going to have to immediately go to the jail, or he will get a time certain to go to turn himself in. Okay.
Yes.
So if that's the case, he needs to get his, I guess I'm just saying that he's going to need to get himself his things in order, because he will either be going at the time or he will be going shortly thereafter. Okay.
Understood.
All right.
So let me just make sure to conform this before I move on to the next person I have on the list. So I have Miss Shirey's case as the next person to call, which skips over Allison Montgomery, Parnav Naratanan, and
can I finish with Mr. Rivas first as well?
I keep you down, Your Honor. I'm so sorry.
I just want to dismiss everybody on this case. Mr. Rivas, we'll see you back on March 1st. And you also, Mr. Mitchell, if there's something further. Okay. All right. Well, have a good day. Bye. Okay. So the next one would be position 14. I know that I have a March 1st status on that. I didn't know if, is anyone on the line for Miss Montgomery? Is Miss Clowney still on?
I didn't think so. I just
Okay, so I don't think so. I know that I've reset that till March 1st. Miss Bridget Bray, did Miss Bray show up for Mr. Naratanan?
Yes, Your Honor. I'm present, and I believe he is on the Zoom as well.
Okay.
And I am still discussing with him if he would like to have a trial or accept the plea. So if we could hold for announcement on that for a few moments, I'd appreciate it.
Okay, I'll hold for your announcement. I just wanted to make sure that you were with us, Miss Bray. Thank you. So just let the court know. And at position 16, I think we're still holding on Mr. Fisher to see what he's going to do with his clients. And the next would be Mr. Merritt, Alex Merritt. Is that right? Position 17.
That is my understanding, and I'm about to reach out to him right now, and that's the last of the group. I am going to circle back to Mr. Fisher, but after that, I'm completed because 18 and 19 have requested jury trials.
Okay, very good. So you're next, Mr. Merritt.
Thank you, Judge. My staff is on standby.
All right, very good. Thank you.
I have an updated announcement on my client when the court is ready.
Okay, give me just a moment, Ms. Bray. Ms. Falk is on the line with another attorney, so as soon as she's available, I'll take your announcement, okay?
Yes, John.
Okay, thank you.
I said, Mr. Shirley, position 17.
Okay.
I have spoken to Mr. Merritt. We have discussed this case. He wants to send me kind of flip-flopping roles this time. He wants to send me evidence and mitigation so I can have an opportunity to look at it and see if I would change my mind on the plea recommendation that's currently on the table. I have told him I have until February 10th to make a decision after he sends me all the paperwork of whether I'm willing to change my recommendation. We are asking that it be placed on the March 1st calendar, so we have an announcement one way or the other.
Okay, that's your understanding, Mr. Merritt.
Sorry, Judge, I had my laptop on mute, so I believe the announcement was we're going to reset it to March 1st if with the court's approval.
Yes, is that fine with you?
It is with me. I just want to make sure I was actually trying to reach my client who I see on the Zoom. Is there any conflict with that date, Mr. Okay, he's giving the thumbs up. Judge, we would just ask to be reset as the prosecutor announced.
Okay, very good. We'll reset you to March 1st. Again, if you do come to terms, please have the paperwork completed so that we can get you in and out as quickly as possible, okay?
Absolutely. Thank you, Judge. That concludes my business. Maybe excuse.
Yes, you all have a good day. Thank you.
Thank you. You too.
And I know that Ms. Braid had an announcement on position number 15. Are you with me, Ms. Braid?
Yes, Your Honor. I've received the state's video evidence and their recommendation, and my client would like to enter a NOLO plea to that negotiated plea.
Okay.
I will say the state is not offering it.
All right, I'll take the NOLO under consideration. I don't know your client's history, Ms. Braid. Once I get his history, and I don't know if I have anyone from pretrial on with me this morning, or are you able to pull up the history, Ms. Falk?
Yes, I can, Your Honor.
Are you able?
But there is paperwork that you will have to fill out.
Right, Ms. Braid, are you able to complete the paperwork from where you are this morning?
I do have a laptop. I'm parked in the parking lot outside of the Atlanta Municipal Court. So I do have a laptop. So as long as my client is able to do it, we should be able to facilitate that.
Okay, okay, and I know that he was on with us. Can you inquire of him if he is in a position to be able to complete that paperwork?
Yeah, would it just be signing a plea form?
You'll have to go through the plea form with him.
I can fill it out. I'm available to fill it out.
Okay, and I can place you two in a breakout room so that you can discuss that plea form if you choose. Ms. Bray, do you have business in the municipal court this morning?
I did.
Okay.
I was in front of Judge Graves.
No, I'm asking because I'm in G33. If you just want to come on down here, if you have the time and do it in person, that might make it quicker.
If it's okay with you, I'd prefer to stay here because I do have I'm back in and out in here.
Okay, you're fine. I was just
Okay.
trying to make it easier on you.
Yes, Your Honor.
So we'll get do we have?
As soon as I get an email address, I just send it in the chat to both of them to send me their email address so I can fill out the paperwork and email it to them.
Okay, and as far as the history goes, I want to.
The history, Your Honor, is, I didn't know you wanted that right now, my apologies.
No, you're fine. If I can just let her know, then she can let her client know, and if he doesn't want to accept.
The updated is October 19th of 2022, and we also show any criminal history. However, I would like to make a request through my office to see if we can pull a driver's history,
Okay.
since that would be more pertinent to this than any criminal history you may have.
Okay, so go ahead and get the paperwork to Ms. Bray when you have the opportunity. I know that we're all busy this morning. We'll get you the paperwork. I'll make a decision regarding the NOLO once I get the history, and hopefully we can get this completed this morning or early afternoon at least. Mr. Maloof, is there an announcement?
Judge, I believe we have a plea. We have sent Ms. Falk the paperwork, gone over the paperwork with our client. This is Demetrius Johnson. This is position number 9. We would ask to be considered for a NOLO plea, but we'd like to enter either a NOLO or guilty. I believe Ms. Falk has had an opportunity to review his driving history. when we had discussions before. I'll let her confirm that, but we're ready to enter a plea at the courts when the court is ready and Ms. Falk is ready.
Okay.
And Your Honor, if I may forward this to Ms. Redden, do you have a way to print something out if I forward this to you? Thank you so much. I'm just emailing this to Ms. Redden so she can print that out for me and I can sign the paperwork so Your Honor can review it.
Okay, thank you. Mr. Kimball, do you have additional business with Ms. Falk?
Just briefly.
Okay, well, give.
Come on, she's printing out. She's printing out paperwork.
Where are my people for my 11 o'clock hearing? Do we know?
I
I
sent
mean,
an email.
who doesn't show up? They're supposed to.
11:30.
Oh, 11:30. Okay, all right. My bad. I don't like to sit and do nothing if I can do something.
Wants to get a no.
Yeah.
No problem. As far as Demetrius.
Let me make sure that we're ready.
Yes, sir.
Are we ready on Mr. Johnson?
I'm ready, Your Honor. If Ms. Falk is ready.
Okay, where is Mr. Johnson?
There he is.
Here he is. So let me just go ahead. Good morning again, Mr. Johnson. Can you raise your right hand for me, sir? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. Ms. Falk?
Yes, Your Honor. Mr. Demetrius Johnson's history is the only thing that we have is a 2018 improper erratic lane change. So he would in fact be entitled to enter a no low plea at this time, since it does not appear he has any other history. The facts of this case, Your Honor, what we would expect to prove this if it were to go to trial, is this occurred on May 23rd of 2021 at Camp Creek Parkway at Center Parkway. Officer Jackson observed a street racing competition that there were several spectators, of which this defendant was one of the spectators. When the officers broke up the street racing, they did arrest him as part of their sweep of that area. And so that is all from the state. The recommendation is 12 months probation that would be suspended. And actually, let me back up, Your Honor. The state is agreeing to reduce the racing to reckless driving instead. And 12 months probation suspended upon payment of a $200 fine in stanter. And let me just be clear, that is in recognition of one, who's a spectator, and two, the fact that he has absolutely no criminal history or driving history since 2018 and no criminal history whatsoever.
Okay, very good. Mr. Maloof, I am going to allow him to use his NOLO in this matter, and he's going to be able to pay the fine plus court costs today. Is that right?
He is, Judge. I told him to anticipate approximately 300 with court costs, if it's a $200 fine. And I did not circle, Your Honor, NOLO or guilty, because I did not know if the court was going to allow a NOLO, but we would certainly authorize the court to enter the NOLO for us.
Okay, that's done. Okay.
Perfect. And he will go down there today to make payment and close the case, if that's all we have, Your Honor.
Okay. Mr. Johnson, it's my understanding that in case 22 CR 007196, you wish to plead guilty to reckless, you wish to plead NOLO to reckless driving. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and if by pleading NOLO to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead NOLO?
No.
I will accept the NOLO plea. Mr. Johnson, it's my understanding that you can pay the fine today. Once you get the fine paid, you'll be done, okay?
Thank you.
You're welcome. Good luck to you, sir. So it's my understanding that you're going to come down here today and get that paid.
Yes, Your Honor.
Very good. Anything further, Mr. Miller?
That's all I have, Your Honor.
All right. I'm glad that we were able to get that done. Thank you for working with us this morning. And you all have a good rest of your day.
Thank you, Your Honor. You do the same.
Thank you. Let's see. I know that we still have Ms. Bray that's going to need her paperwork, and we also are waiting on the announcement from Mr. Fisher. Any announcements, Mr. Fisher?
Yeah, we have a plea for Mr. Chapman, and I'm waiting on to continue to have discussions with Ms. Falk on Mr. Northington.
Okay, very good.
I will send the plea paperwork over on Mr. Chapman to Mr. Fisher.
Okay.
So if I could just have a moment to do both
Yes.
Ms. Bray's and Mr. Fisher's.
Okay, so as Ms. Falk is doing that, we will hold until we get all the paperwork done. Ms. Scott, I see you still there. Are you in need of, do you have any further business before the court? I'm happy to have you, stay with us, but I was wondering if you needed something from us. Apparently not.
No, Your Honor, I don't need anything else. I was
Okay.
just observing.
All right,
Thank you.
you're good. I just wanted to make sure that I hadn't missed something. Thank you.
Okay, thank you.
I have responded to Mr. Fisher's. Mr. Fisher produced some documents. I would like to just take some time to review those. I told him I will get back to him no later than February 10th with my response on whether I'm willing to change my recommendation. So he has received my recommendation. He's asking for something different. And I would like a quieter space to review the documentation before I make any final decisions.
Okay, so can we put Mr. Northington's
On March
case
1st?
on the March 1st status conference?
State's agreeable with that. I don't know if Mr. Fisher is.
I'm here. Can you hear me okay?
Yeah, I can hear you.
Yeah, that's agreeable. What I'll do is I'll reach out to Ms. Falk separately when it's a little bit quieter.
Okay, so March 1st, 9 a.m. If you are able to work it out, please have the paperwork completed so that we can get Mr. Northington in and out as quickly as possible, okay?
March, and that's virtual on March 1st?
I would prefer in court. I would prefer if they just come in to handle these cases if they are going to be entering a plea on that day.
So on that particular case, Your Honor, my client Lionel Northington is a father of a brand new 7-month-old. He lives in Memphis, Tennessee. If we
Okay.
could potentially do it virtual. Yeah.
And just have the paperwork, Mr. Fisher. I understand his circumstance, but if he does enter a plea, please have the paperwork filled out so that we don't have to fill it out on the day of, okay?
And Your Honor, if Mr. Fisher is not in Memphis, Tennessee, we would prefer if he could come into court. Maybe he can sign the paperwork on behalf of his client.
Okay, so why don't we do that? If the paperwork is filled out before March 1st and you have it to the court, then you don't have to come in. If you do not have the paperwork filled out by March 1st, then Mr. Fisher, you're going to have to come in, and Mr. Northington can be virtual.
Okay. And what that's totally fine, Judge. And what I'll do is I may be required to go to Crisp County or Douglas County on jury trials, and I can file those conflicts if I need to.
Okay, and as always, if you get it worked out before March 1st, I can always put you on another plea calendar before that time.
Perfect.
If you get in touch with the clerks, they'll be happy to add you to another calendar before that time. Okay.
That sounds great. And I'll just confirm everything with Ms. Falk. She's been great. I just,
okay.
I know there's a lot going on, a lot of different people here. So I
All
appreciate
right.
it. And I'll go ahead and work on the plea agreement with Mr. Chapman right now. If you can give me
Okay.
minutes, okay?
Yeah, just let us know when you're ready. I have some other
Thank you.
business to take care of.
Thank you.
Morning, so I'm going to go ahead and do that. Ms. Bray, has Ms. Bray received the paperwork?
I did email it to her, yes.
Ms. Bray, did you receive the paperwork?
I've received it. I signed my part. I've sent it to my client. He's reviewing it now and I'm waiting to get it back from him.
So you all just let me know when you're ready to proceed. Also on that case, Ms. Falk, I'm going to need that driving history so I can make a determination as to whether I'm going to allow the NOLA or not.
Yes, Your Honor. I'm waiting to hear back from my
Okay.
staff. I'll reach out one more time.
All right. So the Orca A status calendar will be in recess until we hear back from counsel in that regard. Who is from the state is going to be presenting for the state versus Marcus DeGaulle 11:30 motions calendar?
Ashley Tortorella, Your Honor.
Okay. And do you have, is everyone here for that?
You still need our officers. There's 2 officers from South Fulton Police that are
Okay.
supposed to be here to testify.
All right, so I'll hold till 11:30. Till 11, yeah.
getting past with things.
Yes.
That is, yes. Do you have the plea from Miss Bright, I believe? Yeah. Oh, okay, got it.
Yes.
We're just getting the paperwork in order on Mr. Naratanon. Ms. Bray has sent me the paperwork. I did forward that to Ms. Redden, so we're just taking a moment to get that printed out. However, in the interim, I do have his driving history, and he has no driving history and no criminal history, so technically he would be entitled to use it no longer, so it's just.
Okay. Ms. Bray, are you with me?
Yes, Your Honor.
Given your client's history, I am going to allow the no vote. Sure.
Thank you, Your Honor.
Good to go.
Okay, are we ready to proceed?
We are.
Is Mr. Naretanan on with us?
Yes, I'm right here.
Yes, sir. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Yes. You can put your hand down. Thank you, sir. Whenever you're ready, Ms. Falk.
Your Honor, this happened on, this is one charge of name drag. The incident happened on July 17th, 2021 at the location of MLK Drive and Centennial Olympic Park Drive. The defendant was observed laying drag by Officer Barrett Smith. The state's recommendation on this case, Your Honor, is it's on the paperwork, but I just want to make sure, is 10 days in jail, suspended in stanter upon paying a $500 fine. There would be no probation. But Mr. Naratanan, I apologize if I mispronounced his name, would need to come in by the end of the day to pay that fine.
Okay. Ms. Bray?
Your Honor, I have, excuse me, I've gone over the plea recommendation with my client, and he has agreed to the plea recommendation, and he would be able to pay that today.
And he does understand that there are going to be surcharges to go along with that, so it's going to be over the $500 amount. That's a total. It's
Yeah, I
going to
estimated it to be around $750 or so.
Right.
Is that correct?
Yeah, somewhere around there. Yes. Okay. And he's going to be able to come in this afternoon and get that paid. Is that correct?
Yes, sir.
And okay. Anything further, Ms. Bray?
No, Your Honor. I just thank the court for accepting the no-low plea.
Okay, Mr. Naranatan, it's my understanding that in case 22 CR 007227, you wish to plead a no-low to laying drags. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading no low to it, you're giving up your right to a trial by jury?
Yes, sir.
Is anyone forced or coerced you to plead no low?
No, sir.
I'll accept the no low plea. Sir, it's my understanding that you can pay the fine today. Once you get that paid, you'll be done, okay?
All right, okay. And where do I just go to pay the fine? I just go to the probate court?
You come down to the clerk's office. No, where does he go?
I'll send it to him in the chat.
Okay, we'll send you where you need to go in the chat, sir.
Okay, thank you.
All right, you're welcome. Anything further, Ms. Bray?
No, Your Honor.
All right, you have a good day.
Thank you, Your Honor.
Good going.
All right. And do we have the paperwork for Mr. Chapman?
Still waiting on that. I have not received it yet. Mr. Fisher had one question for me and I responded. He's responded back, but I have not received the paperwork.
Judge, we are filling it out. He's sending it back to me. It's just taking a minute to email back to me. And if I can't get it next minute, I'll just sign with his express permission.
Okay, I'm trying to get you. I've got a hearing scheduled at 11:30. I'm trying to get you in before that, Mr. Fisher. So
That'd be great. So I'll just go ahead and do this with express permission right now.
Okay, that's
All
fine.
right, thank you.
Thank you, Ms. McBrail. I'm happy to have you. Thank you for joining us this morning. We do have the court reporter on the line for the motion hearing. Are you going to be with us also this afternoon for the, and she's also going to be with us for the bench trials this afternoon. Yes, and while we're waiting on that paperwork, just so we're done with the 9 o'clock Orca A status calendar, Ms. Redding is not going to go over it.
Again, this is the Orca A 9 o'clock static calendar. Position number 1, Vaz, request jury trial. Position number 2, Chapman, we are holding for a plea. Position number 3, Claremont, reset status, March 1st at 9. The offer will be held until February 10th. Position number 4, Dragony, request jury trial. Position number 5, Fuller, request jury trial. Position number 6, Harris, request jury trial. Position number 7, due to the leave of absence, reset status, March 1st at 9. Position number 8, reset status, March 1st at 9. Position number 9, Johnson, negotiated plea. Position number 10, Johnson, reset status, March 1st at 9, offer from ASG on the table until February 10th. Position number 11, Cosgrove, reset, further notice because the defendant is in the military, requesting documentation to be submitted to the ASG by early February. Position number 13, I don't know how I'll go back. Position number 12, it's out of order on the calendar. Position number 12 is Marabella, reset status March 1st at 9. Position number 13, Marabella, reset status March 1st at 9. Position number 14, Montgomery, reset status March 1st. Position number 15, Narraton, negotiated plea. Position number 16, Northington, reset status March 1st at 9. Position number 17, Shirley or Shirey, reset status March 1st at 9. Position number 18, request jury trial. Position number 19, request jury trial.
I just got the paperwork and I'm pouring it over to Ms. Redding on Mr. Chapman's case, which I believe is our last plea.
Thank you.
Thank you for your patience, everyone.
Got it.
You want to review or something?
Very briefly. Okay. Mr. Judge, tomorrow. Also, he said, has anyone promised you anything to plead NOLO? And he said, yes. So.
What number is that?
Gonna have to fix that. It's not numbered, but it's on the plea sheet that Mr. Fisher filled out with his client.
Did I make a mistake?
Yes, it asks if anyone is promising something for his plea.
No, sorry. I was trying to get it to you quickly. I'm sorry that no one has promised him anything.
So we'll need to change that on here. I can sign to show that he has provide that to the court.
Thank you. Thanks for catching that.
Okay.
Does everything else look satisfactory?
I could see, yeah.
Okay. Let's see. Are you with us, Mr. Chapman?
You should be on. He was just on a second ago. Sorry, Judge.
You're fine. I don't see him.
Yep, hang on. Judge seems to be joining now. Okay. I'm going to disconnect from you. Go ahead. Judge, he's trying to get on right now. He got disconnected a second ago.
So he's pleading guilty to failure to maintain lane and racing.
We there is going to be some opposition to this, Judge. We are asking if he could plead NOLO to racing.
I will put on the record that that would not change, and my apologies, I forgot to put out the license suspension form. Even if he does plead NOLO to it, it will not change the fact his license will be suspended. And we'll need to forward that to Ms. Redden to print out for me the suspension. That will need to be filled out for it.
Okay, so is there an objection to the NOLO plea to the?
Yes, Your Honor, and I can put the facts on the record. It's not based on history per se, it is based on the facts on the record.
Okay.
And that's fine, Judge. I just told my client I would ask.
Okay, and what was the ask again? The NOLO to which of the charges? The racing?
Great.
To the racing.
Okay.
He's eligible, but in fairness to the state, I understand the opposition. I just told my client I would ask.
Okay. Let me hear the facts and then I'll make a determination.
Your Honor, the facts on this case are on May 9th,
Just one.
Sorry.
No, you're fine. Mr. Chapman is on with us now. Can you hear me? Mr.
Yes.
Chapman?
Yes, I can hear you.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Falk?
Yes, Your Honor. This case, could have gone to trial the state express approved on May 9th, 2021 at approximately 12:23 a.m. Officers were stationary on a ramp from Glenwood Avenue to I-20 West. They observed two Dodge Chargers racing on I-20 West. The vehicle that the officer stopped was the defendant's vehicle, which was the lead car. And at the time, the officer checked him radar going 117 miles per hour in a 65-mile-per-hour zone. As the officer caught up to the suspect, he observed blue lights. The defendant then cut across multiple lanes of travel, drove through a gore, and left to exit onto Moreland Avenue. Because of the speed he was going, he couldn't properly negotiate the curb and ended up leaving the roadway entirely. The officer then conducted a traffic stop. The defendant then drove his vehicle into a parking lot in Moreland, came to a stop. As he approached the officer, as he approached the defendant, he then placed him under arrest for reckless driving as well as the other charges listed. The state's recommendation on this, let me just pull that up really quickly. State's recommendation was this as to count one, that was going to merge with count two. Let me just make sure I have this correct. Sorry, my computer is not being cooperative. If Your Honor could, I could see the. Actually. Here we go. Okay, as to count one, that would merge with count two. As to count two, that would be a $200 fine. As to count three, that would be a $500 fine, 10 days in jail. Count four, the reckless, would merge into count three, and count five, the speeding, would merge into count three. That would be a total of a $700 fine and 10 days in jail. The fines are to be paid in stanter. I have explained that to Mr. Fisher, and he stated his client is prepared to pay those fines in stanter today.
Mr. Fisher, because of the facts, I'm not going to allow a no plea. If he wants to plead guilty, I'll accept the guilty plea.
That's fine, Your Honor. We'll go forward with that. I just told my client I would ask.
Okay, very good. Anything further, Mr. Fisher?
No, Your Honor. And he is prepared to pay, but he is prepared to pay everything today.
He understands that it's not just going to be the 700. It's going to be more than, with the surcharges, more than $1,000 in fines, and he's able to pay that today.
Yes, Your Honor. I explained that to him.
Okay, very good. Mr. Chapman, it's my understanding that in case 22 CR 007242, you wish to plead guilty to failure to maintain lane and racing. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol at the present time?
No.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes.
You have a right to a trial by jury on these charges, and not by pleading guilty to them. You're giving up your right to a trial by jury?
Yes.
Has anyone promised you anything for your plea of guilty?
No.
Do you offer your plea freely and voluntarily with full understanding of the charges against you?
Yes.
Has anyone forced you to plead guilty?
No.
I'll accept your plea, Mr. Chapman. It's my understanding that you're going to come down and get the fines paid today. Once you do that, you'll be done, okay?
Okay.
And just to clarify for the record, because it's the racing, this will suspend his license for 120 days. I am filling out the official notice of revocation suspension. He will need to, and I reached out to Mr. Fisher I'm going to reach out to Mr. Fisher to get the rest of his information, such as his address and his license number. But he will need to, when he comes to pay the fines, surrender his license. because that needs to be attached to this form so it can be sent to BDS.
Okay, did you hear that?
Yes, Judge, I heard that. I want to make sure I'm understanding because he is eligible for a limited permit. So the court, I'm assuming the court will electronically file the disposition with DDS as well today?
Yes.
Okay, so he'll be able to get a limited permit then today or tomorrow.
Okay.
So do you want him to, or does Ms. Falk want him to give the license to the clerk's office or to the finance pay window?
And Ms. Chapman is sending the information.
Okay.
Surrender his license.
Got it.
And then go to the treasurer, the cashier's office to pay the fine, plus being two separate players. But Ms. Chapman is sending it directly.
Thank you. And apparently, Your Honor, Ms. Chapman is currently putting into the chat to Mr. Fisher the two locations the defendant will need to go to, one for the surrender of his license and one to make payment of the fine. Mr. Fisher, when you receive that information, she's, I think, just finishing up. But when you receive that information, if you could confirm that, I would appreciate it.
Okay, did you hear that?
I heard that there's a couple of pieces of information coming to me via the chat. I didn't hear from who though.
Ms. Chapman.
Ms. Chapman will be sending you the information regarding the two locations your client will need to go to in order to pay the fine and to surrender his license. If you could, Mr. Fisher, I'd appreciate if you could send me the defendant's address and his license number so I can put that in on the suspension form.
Okay, can you give me a couple minutes? I'll send it to you shortly.
Okay. If nothing further, once that's done, you all are free to go.
Thank you, Judge. Thanks for your patience.
You're welcome. And let's see, that completes the 9 o'clock Orca calendar. I take it that there's no one else here. It is now going on midday. I call the case of State of Georgia versus Marcus Stegall. And this is the case that needs to be reported, Madam Reporter. Accusation number 22 CR 006292F on the motions calendar this morning.
Is that it, Mr. Fisher? Or Judge?
Yes, you're excused, Lionel. We got notification from the court on how we have to proceed for February 10th and March 1st, okay?
Okay, thank you.
All right, Judge, are we good? Mr.
Yes,
Northington? Okay.
Yes,
all right, I'll hang on for Mr. Chapman. I'll hang on to finish this up.
Thank you.
That's her inside the car. She took it. That's what she took pictures. She was supposed to her the EPO order.
Good morning, Ms. Marshall Story. How are you today? Yes, I just called the case. I'm ready for a presentation as soon as counsel is ready.
Yes, Your Honor. Just I wanted to let you know that for the bond application, Officer Carter, his ETA is about half an hour. So I'm not sure if it'll be the court's pleasure to start with the counsel's motion of
Okay, I think these are part and partial. 11:30 calendars mean 11:30 calendars. They mean that people need to be here at 11:30. They actually mean that people need to be here before 11:30. I understand that the officers have a job to do, but it is now going on noon. But for But for the other calendar running long, we'd be 30 minutes late for this calendar already. So I need for you to have your witnesses present and ready to go when the calendars are at the time that the calendars are set for in the future, okay?
I'm the best, Your Honor.
Okay, very good, thank you. And it's my understanding that the state filed a motion to revoke bond. That motion was filed on December 6th. The defense has filed a general and special demurrer. That demurrer was filed on the motion to revoke bond was filed on December 6th of 2022. The general and special demurrer was filed on December 27th of 2022. It's my understanding that these are kind of part and parcel of the same issue regarding the charge in this case. Is that right, counsel?
It looks like it, Your Honor, but I was arguing about the fact that that's timely.
Judge,
Yes.
I'm sorry. I don't know. I don't know who's speaking and can't hear good. I'm not sure what.
Okay, so we're gonna have to get make sure that we're speaking into the microphone. Counsel for the state, would you announce your name and who you're with?
Yes, this is Maria Jose Tortorello. I'm the represent the state.
Counsel for the defense, would you announce your name and who you're with?
Mike Raffle for the defendant, Marcus Stiegel Sr.
Okay, so given the state's request, I am going to start with the general and special demurrer of Mr.
That's fine, Your Honor, except I would say this, is you need to hear all the facts about the bond revocation and what, make a decision on the general demurrer, but I can maybe throw some light on why. The bond revocation says that there's an incident on May the 8th, 2022, in which he violated his bond conditions. Again, that's over a year and a half ago. It comes after he rejected the state's plea offer and requested a jury trial. This is petty and vindictive. And so what it has to do with my demurrer is that the accusation, and it's been amended very recently. When I filed the demurrer, they amended the accusation, but they did not change the language that my demurrer is talking about. They're trying to say that this was not the violation of the bond, that he violated the TPO on May the 10th, 2021, by going to her residence. And when the court heard the full TPO 8 days later on May 18th, 2021, the court said, we can't, even though the temporary order gave her, we can't, the court said, I can't give her possession and control of the house because she doesn't live there. The son lives there and he's got a lease. So 8 days after that TPO, 8 days after this incident, the court says, I can't give her the house. The son has the house. He can decide who comes, and he's here and he will testify. He can decide who comes and goes. Nevertheless, this whole case is proceeded on the May 10th, 2021, ex parte temporary order. They're not proceeding under the May 18th, 12-month protective order, of course, all of which is expired. And so I would ask the court to wait till there's all the evidence about this bond issue to roll on the demurrer.
And Your Honor, we will object to that. Go ahead, Your Honor.
Okay. Anything further, Mr. Raffle?
No, Your Honor.
Okay, I'm going to take that in as an opening statement. Okay, and
We will object to that, Your Honor. What the counsel is speaking about is a speaking demurrer, which is a demurrer ordinarily cannot rely on extrinsic facts that are not alleged in the accusation. And a demurrer that adds facts not appearing on the face of the accusation is a speaking demurrer,
that presents no authority for quashing an indictment or an accusation and is void. Reaching matters, Your Honor, outside of the four corners of the accusation, there is only one exception to that, and that's only the state stipulated with defense that such facts for the purposes of the demurrer can enter, and there has been no such stipulation. The state has done no such thing, Your Honor, and I do have case law. This is State versus Williams 306.
Okay, hold on for me. I don't know, I've read your briefs. They are very technical as far as the timing goes. I appreciate you giving me the law, but I need to have the facts first before me so that I can have some context. Although I've read your briefs, like I said, they are very time dependent as to what happened when. So could you give me some of the facts of the case and then follow it up with the law that you're arguing for me?
Yes, Your Honor. Hold on 1 second.
No, while they're doing that, if I may be excused, I filled out the suspension form.
Okay, thank you, Ms. Ball.
Thank you so much.
Have a good day.
I appreciate your patience.
Yeah, no problem. I'm glad we got it done. Are you good, Mr. Fisher? Do you need the court for anything further?
Judge, I am waiting, I think, for, I thought I was waiting for something, maybe not. I confirmed the directions. Are we free to go?
Yes,
Okay.
I provided the suspension form to the clerk.
Okay.
And he will have, his license will then be attached to that when it comes in.
Perfect. And then he'll go get a limited permit. Thank you, Judge. I appreciate it. Thank you,
Okay.
Ms. Falk. Thank you, everyone.
Thank you, Mr. Fisher.
Thank you. Bye-bye. Thanks.
Have a good day.
So, Your Honor, as far as the speaking demurrer is concerned, the intrinsic facts that the counsel is trying to bring into this motion, that includes the modified TPO dated on or about May 17th, 2021, the defendant's May 8th, 2022 violation of his original bond order, which was issued May 11th, 2021, that the defendant violated a special condition of his bond. It's in the counsel's actual motion, and these are extrinsic facts that defense is trying to bring into this demurrer motion. However, the law and the Georgia Supreme Court has specifically ruled that such extrinsic facts are void and are considered speaking demurrers and cannot be considered by the court. Counsel needs to focus on the four corners of the accusation, and he has not yet made his case as to how the accusation is defective for a general demurrer.
Okay, well,
And it's untimely, Your Honor, and I can do that argument in a minute.
let you follow up with the procedural at the end. Mr. Raffoff, if you want to make your case, go ahead.
Are we talking about the bond issue or the?
Well, we can't talk about the bond issue right now because it's my understanding that we don't have witnesses here regarding the bond issue. Is that correct?
We have the victim. We're just waiting on Officer Carter from South Fulton Police.
Okay, so is there anyone that you can present at the present time regarding your motion to revoke bond?
We can, Mrs. Norfleet.
Okay, so let me just, before your request, it was my intent, because your motion was filed first, to take up the motion to revoke bond first. So if you can present evidence to start with the motion to revoke bond, I'd rather start there and then take up Mr. Raffoff's issues.
Your Honor. Okay, Your Honor, the state's asking for you to revoke the bond that was set for defendant Marcus Stiegel Sr. under case number 21 CP 199773, when this case was up in Superior Court. Your Honor, the state would like to state the procedural posture of this case. The defendant was granted a $5,000 surety bond on May 11th, 2021 in the Superior Court of Fulton County. Conditions of this bond order included to stay away from the address located at 7945 Rivertown Road in South Fulton. The defendant violated conditions of his bond order for this case when he returned and was present at 7945 Rivertown Road on May 8th, 2022. The state filed a motion to revoke bond involving the defendant on December 6, 2022. Your Honor, today we will put Officer L. Carter of the South Fulton Police Department on the stand, and his testimony will prove by preponderance of the evidence that the defendant violated his conditions of bond by returning to 7945 Rivertown Road within the bounds of Fulton County after the defendant was issued the bond order. We will also provide proof that this defendant poses a risk of not only, well, scratch that, Your Honor. To make very clear, Your Honor, the defendant's bond was modified after the actual violation took place. The defendant violated his bond on May 8th, 2022, and the bond order was modified by Superior Court on August 25th, 2022. And shortly thereafter, Your Honor, this case was transferred to state court. Your Honor, the state respectfully asks that you grant our motion and revoke his bond on this case, which turned from 21 CP 199773 to 22 CR 006292F because the defendant violated his bond conditions when he had an active order to stay away from said residence. Your Honor, at this time, I'm going to be tendering a certified copy of the defendant's bond order into evidence for case number 21 CP 199H773 under OCGA 24-9-902, which allows such document to be tendered because it's self-authenticated. That states Exhibit 1.
Any objection, counsel?
I don't believe I'll have them, but I would like to see it before.
Of course.
I don't have any substantive objection.
It's attached to this, unfortunately. But I can ask the judge to only consider this. It's certified.
Let me see. I just want to see. No objection.
Okay, admit it without objection.
And Your Honor, in all fairness, this document is attached to other documents that we just take into account this whole document that's been certified.
Yeah, I have it as a single document if the court would rather substitute my D5 for the states.
Mark it, Your Honor, sorry.
Okay. He says he has the document.
Yes, I have a single document
with you?
D5, except it is highlighted, but it is marked and it's a single document.
Is it certified?
No, it's been certified,
Okay.
but it's the same. You can compare them.
It's fine. It's not certified, Your Honor.
Also, Your Honor, respectfully, the state would mark that Ms. Tortorella was the state exhibit number 1. And then if the state might inquire, since the court reporter is not physically in the courtroom, to whom should we tender as the custodian of records for any exhibits of the state?
Get it to me and then I'll get it to the court.
Thank you, Judge.
Okay. Can we just, I don't want to take his highlighted copy and put that in the record. Can we make a copy of this? Just that page? If that's all right with you, Mr. Tortorella.
That's fine, Your Honor. And nothing further from the state. That's the end of my argument.
Well, I would just suggest that if it's a copy, then it's not certified, so my copy should be just good.
No, I'm saying no.
Okay, if you want me to put your highlighted copy in.
No, I'm just saying, I've got a copy ready. That's all.
Okay. You have another copy that's certified?
No, not certified.
Okay.
Do you have an opening? Or
I can't hear you.
do you have an opening that you would like?
Thought I made it.
Okay, let me go through. Right. And Your Honor, since defense has already made his opening statement, at this time I would call to stand Ms. Tracy Norfleet.
Okay. Does she just want to come up to the podium?
Or
There's no seat over here.
which one?
You come around now, so you don't come in that door.
And there's a chair. Please click on the chair.
I know.
You want to stay here? Whichever best for you guys.
Yes, ma'am. Thank you.
You can look at me directly.
Raise your right hand. You swear affirm that the testimony you're about to give is the whole truth, and that's but the truth about you. Start middle of your hand.
Pull the microphone down closer to your.
State your name for the record.
I'm Tracy Norfleet,
Okay, can you spell it, please?
TRACEYNORFLEET.
Ms. Tortorella, I apologize. In this courtroom, you see it's rather large. We're gonna have you on the microphone also, especially since we have the court reporter not here with us present, but on Zoom. So she's gonna, you're gonna need to speak into a microphone as well. Madam Court reporter, if you can make me aware if you cannot hear, so that at least I'm aware, okay?
What was your previous last name?
Stigall.
How do you spell that?
STEGALL.
And please explain why your name has changed.
I was recently married.
Okay.
I cannot understand or hear. Should she take off the mask?
If she feels comfortable with the mask off, she can.
I was recently married.
Okay, so you're remarried.
Yes, ma'am.
What do you do for a living, Mrs. Northleet?
I'm a account manager.
Were you involved in the incident where police were called because the defendant Marcus Deagle was at 7945 Rivertown Road on May 8th, 2022?
Yes.
Can you point him out and state for the record what he is wearing?
Marcus Deagle wearing a black jacket right here.
Okay. Let the record reflect, state's witness Tracy Northleet has identified that the defendant Marcus Deagle.
So reflected.
How do you know the defendant?
We were married.
Okay. Did you live with him before?
Yes.
Are you currently living with him?
No.
Okay. What was the address at the time of the incident?
7945 Rivertown Road.
And is this located in Fulton County, Georgia?
Yes, it is.
What day did May 8th, 2022 fall on? Do you remember any particular holiday?
Yes, it was Sunday, Mother's Day.
Okay. And who did you speak to that day?
My son.
Okay. And what's your son's name?
Trayon Stigall.
Okay. And how did you communicate with your son?
Telephone.
Did you attempt to communicate with him again that day?
Yes, I did.
And why was that?
We had spoke on getting together for the holiday for Mother's Day and possibly going out to eat. And it was unfortunately late when I called him, but he told me he wanted to go out earlier that day, and I didn't know that.
Okay. And what was your son living at the time?
He was living at 7945 Rivertown Road.
Okay. And how did you end up at the Rivertown address?
I went down there because he wouldn't answer the phone.
Okay. And what did you immediately observe when you pulled into the residence?
I observed Mr. Stigall's black Denali truck parked in the carport and a blue, I think it was a Yukon SUV parked behind him. And I observed all the lights off except for a TV in the living room was on.
Okay. Is this the only vehicle the defendant drives?
Yes. Well, I think his fiance, she have a small car.
But his vehicle?
His vehicle?
Is that the only vehicle that he owns and he drives?
I'm not sure.
Okay. But you have prior knowledge. Why do you have prior, well, how are you so sure that was his vehicle is my question.
Oh, he had the vehicle, I think he purchased it before we separated.
Okay. And what else did you observe?
When I pulled into the yard and someone noticed my headlights, I seen a male figure in the window, and then the lights, the TV went completely off.
Okay. So who was this person?
Mr. Steele.
How do you know?
Well, when I called the authorities down there, because I knew that he didn't supposed to be down there, and my son wasn't there because his car was not in the yard, I called authorities, and authorities came down and they confirmed they spoke with him. And then shortly after my son pulled up, he stated he was at his girlfriend's house and he had fell asleep.
Okay, but when you observed them, when you approached property in your vehicle, when you observed the figure inside, how did you know that was him?
Well, I kind of know his physique, and it's no one else that would be in the house. No one else would have access to the house but my son and him. He won't even allow my youngest son to come to the house. His car was there, so I already pretty much know, and I know he'd be there. So I already knew, and the police confirmed it.
How many years have you known him, Mr. Steele?
We started dating at 16 years old, 24, almost 30 years.
So, what happened after you noticed that the defendant was inside the house?
I immediately left. I immediately departed. When I see his vehicle, I was like, oh, my driveway is like a one way. You have to turn around, back up, turn around to go back up the hill. And the hill is maybe 100 yards long, feet long. It's really long. So as I pulled in and I noticed the car and all the lights off in my car, my son's car wasn't there. I had already proceeded to turn around. And as I was still looking back in the turnaround, the lights went off. So they observed my vehicle. He did. And I departed. I went to the top of the hill and I notified authorities.
Okay. So you mentioned that you notified police?
Yes.
Okay. What happened after you called the police?
They arrived to the scene. I told him it was a TPO and a bond. I believe I told him he had a bond. He was on bond, and the bond he's supposed to stay away from the residence. And the officer spoke with him. He told the officer that I'm always harassing him. And the officer just did an incident report. He stated that he didn't want to get involved. It was a civil matter. He didn't understand. So he told me to see it in court. They just did a police report.
Okay. Nothing further. Oh, right. So going back to when you pulled into the property, how clearly were you able to see the person who was inside? Or Mr. You already confirmed it was Mr. Steele. So how clearly could you see?
It wasn't very clear.
Okay. Was there any obstruction?
No.
But if it was not very clear, how did you know it was him?
Because I knew the male figure. I know him.
And did you observe the defendant speak to the responding officer?
No, ma'am, I did not go back down there.
Okay. And how
I waited for the officer. When I went to go get the paperwork because I was not inspecting it, and I should have because he's been down there several times, and I've told authorities several times he don't supposed to be down here. He's on bond, and according to the bond, he don't supposed to come around this property, don't supposed to be around me. I told dispatch, I said I have to go get the paperwork because I knew that the police was going to be confused. So I said, I'm going to get the paperwork. I'll be right back.
Okay, but I'm sorry to cut you off, Ms. Norfleet, but so you said you didn't observe him speak to the police. So how did you you could answer the question, how did you know that he spoke to a police?
I spoke with the police.
Okay.
Over the phone. I told them I came back. I talked with dispatch, and I said, "Where's the officers? I have the paperwork." And they say the officers departed. And I said, "Well, can you have the officers contact me?" The officers contact me, and they told me what was said and what was done.
Do you remember the officer's name?
It was 2 officers. Because they started kind of pointing the finger. Well, this officer took the paperwork, and this officer wrote the report. One of them, I believe, was Carter.
Okay. Did you spoke to Officer Carter?
I believe it was Carter. I have to look at my police report to see, but it was 2 officers, and I'm not sure which one, but I know it was a Carter, I believe, at the scene. Okay. He was trying to instruct him. I guess one was in training or something. I'm not clear on that.
But you did see his vehicle, Mr. Siegel's vehicle on the property?
Oh, yes, I did see that, clear.
And upon, I'm going to ask this question, upon you coming into the property and observing the male figure, how certain are you that it was the defendant?
Well, I'm not going to say I was. You mean like, I was 100% certain it was him.
Okay.
But I didn't clearly see his face, but I'm 100% certain it was him.
And how did you came up to that conclusion of 100%?
Because his vehicle was there and I seen the male figure and he was sitting in the living room, and I know he's the only one sitting in the living room and watch TV. So based off of history, I guess I know him.
Nothing further.
So when you came to 7945 Rivertown Road on May the 8th, 2021, you have a copy of the 12-month restraining order with you. Is that correct?
No.
Objection, relevance.
It's a cross.
I thought you said you had a copy of the order.
Court reporter is attempting to say something.
Yes.
Sorry, I cannot hear counsel.
You're going to have to speak into the microphone, Mr. Raphael.
All right.
Thank you.
Okay. So I'll repeat the question. So when you came to 7945 Rivertown Road on May 8th, 2022, you're saying you didn't have a copy of the restraining order with you, the TPO?
I did not have a copy.
Did not have it. Do you know what it said?
Yes, I do.
What did it say?
The TPO stated that he can only be on the premises under permission of our youngest son, Trayon Stigall.
Okay, and the same goes for you. You could only be there with his permission, and you said you didn't get it because you couldn't reach him on the phone.
No, I already had permission, sir. I spoke with my son earlier that day.
Okay. So you called the police. Did they have access to this 12-month restraining order?
No, sir, not at the time when they arrived to the scene.
And isn't it true that paragraph 7 of that restraining order, and I'll show it to you.
If I can see it, counsel.
No, I got a copy for you. Hold on. It's exhibit. 6, D6. You can have it. Is that my original? I'm sorry.
It might be original.
It is. I'm sorry. There you go. Yeah, I would, for the court, I would. This report consideration. We'll move to, enter it as appropriate now. D6 is the one we're talking about. Paragraph 7. Okay, let me hand you D6. Paragraph 7. Could you read that out loud for us? Paragraph 7.
The property located at 7945 Rivertown Road, Fairburn, Georgia 30213 is currently occupied by the party's son, Trayon Stigall, pursuant to a lease. As a result, neither party is awarded sole and exclusive use of possession of that property. However, either party shall be entitled to be present at the residence at the invitation of the leasee, except that the respondent shall vacate the premises in accordance with the terms of this order. In the event the parties find themselves at the property at the same time.
So that's that is what was in effect on the day, on May the 8th, 2022, correct?
No, sir. I was informed that the bond superseded this.
But I'm not talking about the bond. That's another issue. I'm talking about the TPO that you saw said he could go there, right?
Well, the TPO stated this, yes.
Okay. All right. And you knew that, correct?
Well, the bond superseded this. That's what the judge said. The judge stated that the bond superseded.
What judge said that?
The judge in the TPO hearing.
What was the judge at the TPO hearing commenting on the bond?
Because I told her that he's still.
Relevance to this bond hearings.
Move to strike. It's hearsay anyway. Okay, so. And again, this is this order issued 8 days after you had the ex parte temporary order, correct?
I'm not sure how many days.
And the reason the judge put that in there, because you said you owned and lived at that property, 7945 Rivertown Road, isn't that correct?
Can you repeat the question?
You originally on May the 6th, 2021, when you procured the ex parte restraining order, you said you lived at 7945 Rivertown Road in Fairburn, Georgia.
I stated that's my property.
But on 8 days later, or 12 days later, on May the 18th, 2021, when the judge heard their evidence, he found you didn't live there. Isn't that correct?
But that's my property. Neither one of us live at the property.
Pardon?
Neither one of us live at the property. Both of us have another residence, and we both went to the property. We both have furniture. I still have furniture there. I was still going there. So when you say live there, when you have two residents, I mean, my address on my license still was at that residence.
You had two residences that day. Is that what you're saying?
Yes, I was at both places.
But the judge said on May the 18th, 2021, you couldn't go there unless you had permission from your son.
Yes.
Okay. And he could go there if he had permission from
That's
his son.
correct. That's
Okay. All right. And is that the reason the policeman would make an arrest?
Is that the reason why they would? I don't
Why they would not make an arrest on May the 8th? You said that you called the police.
She doesn't know, Your Honor.
Well,
Well,
if she doesn't know, she can say she doesn't know. Ask your question, Mr. Rappa.
Didn't the police have a copy of that order that day?
No.
Didn't they tell you they couldn't arrest him?
Yes.
Okay, all right.
Oh.
Now, and you took a warrant out on May 10th, 2021, which set up this bond order, correct?
No, sir.
You didn't?
No.
Well, you originally called and reported that on May the 10th, 2021, that he was at 5200 Cotter Drive.
That's correct.
That's where you were actually residing, correct?
No, sir.
What's
That's another one of my properties. And my son was residing there, my oldest son, Marcus DeGaulle Jr.
you reported that he was there,
He was there.
and you had that officer from Union City serve him with a copy of the ex parte temporary restraining order, correct?
Correct.
Okay.
I didn't have him do it, but
Pardon?
I provided it and he took it upon himself to serve him because he stated he
Right.
was.
So he got served on May the 10th, 2021, correct? You saw that?
Yes,
Okay. And later, a couple hours later, you made another report to the police, didn't you?
yes,
On May the 10th,
I did.
2021.
I
And what was that?
When Officer Lee Muhammad, Union City officer, advised him to stay away from both properties according to the TPO. And he told him, you cannot stop me from going to my property. That's my house, I'm going. And the officer told him, sir, if you go down there and she calls the police on you, and if they arrest you, that's on you. Mr. Gall ignored the officer. He proceeded down there and I called the police.
You did. I didn't hear what you said before that. What made you call the police the second time?
Because Mr. Stigall disregarded what the police just told him and went to the second property that I own, 7945 Rivertown Road.
The second property being 7945 Rivertown Road, which the judge on the 8th, a couple of days later, said is not exclusive of your property. It belongs to the son, correct?
No, I don't believe that what is stated that.
Well, you just read it, paragraph 7.
No, the initial one that I filed is there for him to stay away from the properties. And then we had another hearing, if I'm not mistaken, in the second hearing, it went before, we had another court hearing. We had a court hearing and she stated that we could only go when my son is there because.
So you called the police because you saw his truck at 7945 Rivertown on May the 10th, 2021.
I followed him to the residence. And then, yes, the same truck that was in Union City, the same exact truck that was in Union City, I followed him and he went to the residence. That truck was spotted at 7945 Rivertown with the same tag. That means that he went to that property, so I called authorities.
Because his truck was there, that meant that he went there, correct?
Yes, sir.
Okay. And the police came and he wasn't there, was he?
Well, they didn't go inside the house. And
He didn't what? I'm sorry.
They didn't go inside the residence.
Okay. They didn't see him and they didn't find him. And they put that in the report, didn't they? They said,
Well, the property is 16 acres. It's 16 acres on a property. They didn't search the entire property.
well, they said they made no contact with him, but they said his truck was there,
Yes,
correct?
that's correct, sir.
And so, but that was the basis of his later arrest, correct?
No, sir.
Well, when was the warrant taken? Do you know?
Yes, so while I was there at the top of the hill and they was down there knocking on
Objection,
the
Your Honor.
door.
This is irrelevant to a bond here. We're talking about warrants now, Your Honor.
This is when the bond got set after this incident,
Motion to strike, Your Honor.
because of this incident.
I'm still trying to figure out what's going on, so I'm gonna let you continue, Mr. Rowell.
Okay. Go ahead and finish answering.
So now the bond, the TPO stated he do not supposed to make contact with me. He do not supposed to go to the residence. So when I went down there, I called the police. The police did not make contact with him. However, the officer was at my vehicle talking with me when Mr. Stigall called me. He heard the conversation. He said, listen through the phone. I had him on speaker. The officer, and I believe he was a sergeant or superintendent, a supervisor. He heard him. He said, that's enough. He heard him talking, saying, Tracy, why you doing this? And some other stuff he was saying. And he said, that's enough. Hang up. I got enough. I heard it. and he placed the warrant.
But that didn't take a warrant for him making a telephone call. They took a warrant for him being
No, sir.
at 7940.
No, sir. The officer took a warrant out because he contacted me to my knowledge. He was not.
Well,
supposed
do you
to
have a
contact
copy
me.
of that warrant?
I know I never obtained a copy.
You know why we're here?
Because he revoked his bond.
No, they haven't revoked it yet.
Oh, I'm sorry.
Okay. But we're here because you took a warrant saying on May 10th, that you knowingly and in a nonviolent manner violate the terms of a temporary protective order by returning to 7945 Rivertown Road in South Fulton, the residence of Tracy Stiegel. Isn't that what this case is about?
I called authorities. Authorities said, I'm going to issue a warrant right now. He issued a warrant.
Because you told him you had
But
a court order giving you possession of that of 7945 Rivertown Road.
Well, I did have two. He contacted me and his car was there. I followed him there, and the same car that was in Union City was now at 7945 Rivertown Road. And this is before my son had permission to give us permission. So when I first filed it, no, he could not go there.
But later, on May the 18th, that was changed, correct?
I believe it's
Because the court rejected what you stated under oath, that that was your house. It said, no, it's the son's, correct?
No, sir, it's not my son's, and my son do not have a lease. My oldest son have a lease. Trayon Seagal never possessed the lease. The judge was confused because it's so much. My oldest son have a lease at 5200 Carter Drive. Trayon just lived at the residence because he was 18 years old. He never obtained a lease. The judge, after hours of hearing the case, stated, well, your son is living at the property. We do know that because him and we both have other properties. And so he doesn't live there either. He go there frequently because he run a bootlegged business there. But I'm sorry, Your Honor. I'm sorry, I guess you have to. But he goes there because he operates his business there.
And he got permission. He got his bond order changed and he got the TPO order changed so he could go there, correct?
He got a bond change. The TPO, I don't know if he didn't have that modified. That was just in the court hearing.
So you're saying the judge made a mistake by saying that wasn't your property?
Yes.
Because
I paid the mortgage for this property. Mr. Seagal don't pay anything for this property. My name is on the mortgage. His name is added on the deed because he kidnapped me and forced me to put his name on the deed.
Bond hearing.
Okay, I should sustained.
Okay, so his name is on the deed.
Yes, not
or
the
no?
mortgage. I pay the mortgage. I'm solely exclusive on the mortgage by myself. And he refused to pay anything for this property that he's running his business out of and that he's claiming that he lives in. But he have another property and he stays at his fiance's house as well.
And you're still very bitter about your relationship with him, or you're not bitter?
No, I'm not bitter.
You had him served today with new papers, correct?
Yes, sir.
Outside the courtroom, they served same case.
Yes, because he stole my vehicle. He's supposed to be paying me for the vehicle that he stole.
That's not relevant to any of this. Go on.
Oh, yeah. So again, you did not see him on May the 8th, 2022 at 7945 Rivertown Road.
No, the officer observed him.
The officer put in his report that he didn't.
No, the officer stated you made contact with him at the property.
And Your Honor, we do have the officer here as our next witness.
Oh, he does, well. Chief. Again, I think I asked you this already. I'm gonna ask you again. The officer wrote in his report, contact was not made with Mr. Stegall, and I thought you had admitted that. Now you're saying contact by the officer was made with Mr. Stegall
On the
on May the 8th.
On May 8th, 2022, contact was made. On May of 2021, contact was not made.
You're saying he violated the bond order.
Yes, sir. He did because the bond order.
Okay, you know what date he violated the bond order?
Yes, sir.
What date is that?
May 8th, 2022.
And then again, how did he violate that bond order?
Because he was found by authorities at the premises, at the residence, and the bond order stated to stay away from 7945 Rivertown Road.
So again, you didn't see him, but you think he was there. Is that what you're saying?
I seen his vehicle, I seen his figure in the window, and the officers seen him.
That's all.
Any redirect?
Hello, Mrs. Murphy. So going back to the bond, you observed the defendant at the Rivertown Road address, is that correct? On May 8th, 2022, who did you see inside the residence?
I seen the figure of Mr. Stegall.
And how sure were you that was his figure?
I was 100% sure, and the officers confirmed that.
Okay, nothing further.
All right, thank you, ma'am.
Thank you.
Thanks. Call your next witness.
The state will call Officer Carter from the South Fulton Police Department to the stand.
You raise your right hand. You swear or affirm that the testimony you're about to give the whole truth and nothing but the truth.
I do.
Or you lawyers.
Please introduce yourself to the court.
Sergeant Lewis Carter, with the City of South Fulton Police Department.
How long have you been employed as a police officer?
How long have I been with?
How long have you been employed as a police officer?
With South Fulton since they started 5 years.
And overall?
14.
How many hours required for post certification, officer?
I can't really.
How many hours required for post certification?
480.
And what is the next step after completing your post training?
You go to whoever you're hired with, you go through field training, and then after you complete field training, that's when you hit the road.
And how long does that take?
It can take between 6 and 11 weeks.
Okay, I mean, I'm happy to hear it if you want to continue.
I do want to continue.
Okay.
Excuse me, Your Honor, let's turn around. Huh? So you are a post certified, are you a post certified officer?
Yes, I am.
And were you a post certified on the date that you responded to the incident location on May 8th, 2022?
I was. Now be mindful, I was also with another officer, Officer McDonald. He's no longer with this agency.
Okay. Have you had experience with cases that deal with any sort of order violation?
Yes, I have. They usually, if it's TPO, they usually provide the documentation. We don't go off of hearsay. You have to have some type of documentation to advise that an individual has a temporary protection order or a stay away order.
Okay. And how many of those types of cases have you been called out on, would you say?
A lot. I can't give you an exact number, but a lot.
Would you say like over maybe 20?
Yeah, over 20, yeah.
At or about May 8th, 2022, at 10:55 p.m., were you on duty?
I was with Officer McDonald.
Were you in uniform to include your badge?
I was.
Were you in a marked police vehicle?
I was.
Did the incident involve the defendant, Mr. Marcus Jermaine Siegel?
It did.
Are you able to identify him?
Gentleman right here with a black blazer, blue mask, and a black shirt underneath.
Let the record reflect the witness, Officer Carter, has identified the defendant, Marcus Siegel.
So reflected.
Were you dispatched to 7945 Rivertown Road in South Fulton, Georgia?
I was. It was in reference to a 39, which is information for officer.
And is this location within the bounds of Fulton County, Georgia?
Correct.
What happened when you arrived at the scene?
Prior to arriving to the call, in the notes of the call, the complainant was a female. The female advised that she was in a Tesla. I want to say it's Miss Stegall. Is that how you pronounce it? Stegall. She indicated that Mr. Stegall was at the residence, and he was not supposed to be at the residence. We never made contact with Ms. Stegall that evening physically. Officer McDonald called her via landline, but we did make contact with Mr. Stegall, and he indicated that he did have rights to the property. His son lives at the property with him, and I guess him and his wife have an ongoing domestic dispute, and indicating that she had been harassing him, trying to get him put in jail.
Did he admit to you that he was at the residence?
Yeah, I saw him. I talked to him. He came out of the residence. He actually indicated that that residence was his, and he was going to be, I want to say, building a winery at the location.
And what happened after you spoke to the defendant that day?
We just documented it, just due to information for officer. Like I said, we never made contact with Ms. Stegall, so that, and due to that, not making contact with her, we couldn't indicate that she had physical evidence of stay away order, a temporary protection order.
What do you mean by didn't make contact? Did he not come out of the residence?
He came out, but she was the actual caller. And he actually felt like he was being harassed due to the ongoing, the police presence coming to the property.
So you did observe him come out of the residence?
I did, yes.
Nothing further?
You're South Fulton Police Officer.
South Fulton, yes, sir.
And who is Corporal or Officer Fuller?
Officer Fullerton, he's not here right now, but he is a police officer. He has been, I want to say, employed with City of South Fulton for 4 years.
Let me hand you what mark D3. And do you recognize D3 being an incident report from May the 10th?
This is when he, okay.
Yeah, so May the 8th.
Right.
Okay. All right. So you saw Mr. Stegall at 7945 Rivertown Road on May the 8th, 2021, correct?
Right.
You did not make an arrest, correct?
I did not.
And you didn't have probable cause.
I did not.
And you did not have knowledge of any CPO that was in effect.
I didn't.
You didn't have knowledge of any bond that may have been in effect.
I did not.
That's not like that.
Anything further?
Nothing further. Nothing further for this witness, Your Honor.
Can the officer be dismissed?
Yes, Your Honor.
Thank you, sir. We appreciate your time. Call your next witness.
May I proceed with my closing statement, Your Honor?
No, because I'm going to allow Mr. Rapoff to present any evidence that he might.
Oh, I'm sorry. Yes.
Mr. Rapoff, do you have any testimony or evidence that you would like to present?
Yeah, I just want to go through the exhibits, which I've been tendering. D1 is the original ex parte emergency TPO. which we did concede, said he couldn't go to 7945 Riverton Road. That was on 5/6/2021. And 5/10 is the Union City incident report of 5/10/2021. Now, the only thing is, one of the things that's confusing about this case is that the original incident in that was at her residence, which was 5200 Otter Drive.
Okay, so
then
why
she
don't you do this? Why don't you're gonna tender evidence, so go ahead and tender the evidence. And then in your closing, I'll let you argue anything you want to argue for me. So if you're telling me that you're not gonna have any witnesses to present, if you're telling me that you're not gonna have any witnesses to present, that you just want to tender these documents, why don't you go ahead and seek to tender the documents? Once you tender the documents, then I'm gonna let you comment on the documents in your closing argument, if that's what you want to do.
We will call.
I'm sorry, Your Honor, we will object to such documents being tendered. They're irrelevant to this bond revocation hearing. This is regarding a TPO civil matter, Your Honor. And it also includes Union City Police report that has no relevance, again, to this bond hearing, Your Honor. That's for the demurrer motions, if he wants to argue that. But for purposes of the bond revocation hearing, we are objecting to such documents being tendered.
Okay, we will call at this point, we will call the son, Marcus Stiegel Senior.
Okay.
Junior. Trayon, I'm sorry. Trayon Stiegel. I'm sorry.
Have him spell his name also for the court, please.
You're saying what? Mr. Would you raise your right hand?
Have it.
Oh, I'm sorry.
Please raise your right hand. Well, affirm that the testimony you're about to give the whole truth and nothing but the truth, so help. Yes. You lower your mask while you testify.
Would you state your full name for the record? And how are you related to Marcus Stiegel Senior?
That's my father.
Okay.
Your Honor, I can hardly hear him. I don't know if you can.
That's my father.
Why don't you pull that chair up and sit down in the chair? Maybe that'll make it easier for you.
And on the, where do you live right now?
7945 Rivertown Road, Sherman, Georgia, 30213.
And that's the same residence that's in dispute here today?
Yes.
Okay. And did you live there on May of 2021?
Yes.
Okay. And you're aware that the court gave you authority to decide who would come to 7945 Rivertown Road?
Objection, reading.
Go ahead.
You can answer.
Yeah. Yes.
Okay. And did you allow your father to come to that residence on May the 10th, 2021?
Yes.
And did you allow him to come to that residence at other times thereafter?
Yes.
Okay. And are you aware or not whether there was court orders to that effect?
Can you repeat that?
Were you aware at the time he visited that the court gave, was it you and your brother?
Just me.
Just you. Gave you the authority to decide who would come to that
Yes.
residence? Okay. Was he ever there at the time without your permission?
No.
That's all I had.
Yes, Your Honor, one moment. Is your name Treon Stiegel, correct?
Yes.
And you are Mr. Mr. Stiegel's son, correct?
Yes.
And you're also the son of Mrs. Norfleet?
Yes.
Okay. You're the youngest, correct?
Correct.
And You currently live at 7945 Rivertown. You got Rivertown address?
Correct.
Okay. And on May in 2021, you lived there, correct?
Correct.
And the TPO order doesn't really allow you to any sort of discretion as to who is to come to your house, correct? It's your older brother?
You repeat that?
Your older brother only has that authority to decide who is allowed to come to the 7945, correct?
No, that's not correct.
And on May 8th, 2022, your father was at that residence, correct? You're under oath.
I plead the fifth.
Nothing further.
But you are Trayvon Stiegel, correct?
Correct.
And you're the Trayvon Stiegel, listening in paragraph 7 of the 12-month protection order. Isn't that correct?
I didn't
The
get
court
that.
reporter can't hear what's being said.
You are the Trayvon Stiegel mentioned in paragraph 7 of the 12-month protective order that says you have a lease to that house. Is that correct?
No,
You don't know?
I don't know.
Well, paragraph 7 speaks for itself. It says, the property located at 7945 Rivertown Road, Fairburn, Georgia, 30213 is currently occupied by the party's son, single, Trayvon Stiegel, pursuant to a lease.
Yes, that's correct.
Okay. And that lease was in effect in May of 2021. Isn't that correct? If you know.
I don't know.
Okay. That's all.
Anything further from this witness?
Oh, I'm sorry. I forgot to. Okay.
Okay.
If I could, Your Honor.
Go ahead.
On May the 8th, 2021. On May the 10th, I'm sorry, 2021. Is that right?
Yeah. 10th, 2021.
Was your father's truck parked at 7945 Rivertown Road?
Yes.
And was there a reason it was parked there?
Me and my dad, he called me early in the morning before I went to work to meet him at a local gas station, and we swapped vehicles. He needed to drive my vehicle to save gas, so compared to his truck. And he later came back while I was at work and swapped the vehicle back.
Okay. Thank you. That's all I have.
Yes, Mr.
So you just testified under oath that your father was present at the Rivertown address on May 11th, 2021, correct?
Can you speak into the microphone, please? I'm sorry.
So you just testified under oath that your father was there on May 11th, 2021. Is that correct?
I can't remember.
They didn't say that. You said they met.
Hey. So if you want to make an objection, make an objection. Otherwise, if you don't know the answer to the question, say, I don't know. Ask your next question.
So he was present on May 10th, 2021. Is that right?
Yes.
At
Wait, no.
at the
Wait,
Rivertown
I don't know.
address.
Wait, I don't know.
You don't know now? Okay. And then on May 8th,
I don't know.
22, was he present?
I don't have any further answers.
Okay, nothing further.
All right, can this witness be excused? All right, call your next witness.
Are you gonna say whether you were present or not? I don't think you should do it. You decided. I'm gonna put you up in SCP. Let's put that. Yeah, we'll call Marcus Stiegel Senior.
Okay.
Please raise your right hand. You swear affirm that the testimony you're about to give is the whole truth and nothing but the truth, so help you.
Yes.
May lower your mask as you testify.
Okay, so let me just make this clear, Mr. Raffoff. Although this is a bond hearing and a general and a special demurrer, your client is under oath. He has been charged by the solicitor's office with a violation of Georgia law. As such, he's going to be able to be cross-examined by the solicitor in regards to this seems like it all comes out of the same transaction and occurrence as to what he is charged with. So it will be on the record. So it's my understanding that you're going to have Mr. Stegall testify in this case. Mr. Stegall, you've been advised by Mr. Ratliff regarding your rights to remain silent and that anything can be used against you.
Oh, yes, Your Honor.
Okay, and that you understand that you're under oath. Have you consulted with your counsel as to the ramifications of what your testimony can lead to?
Oh, yes, Your Honor.
I don't think I was gonna ask him.
It's not what you're gonna ask him, Mr. Raffoff, it's what the solicitor is gonna ask him.
But then I would suggest that you not testify then.
Okay. I thought that might be
Okay.
a better course of action.
Okay.
Any other witnesses?
You have me now, your court appearance. You have no criminal record.
Not for the, not on behalf of the state, not for the bond ratification.
I did not hear that. I'm sorry.
Any other witnesses or any other?
Yes, Your Honor, I do have my exhibit package. I would tender D1, which is the original ex parte emergency TPO.
Okay, let's go one by one. Any objection to the protective order?
Yes, Your Honor, there'll be an objection.
State your objection.
It's not relevant to the bond revocation, Your Honor, to the issue at hand. Whether or not he actually revoked his bond, not his TPO.
Admitted over objection. Next.
D2 is the 5/10/2021 Union City Incident Report.
Any objection?
Yes, Your Honor. Again, that has nothing to do with the May 8, 2022 incident.
If the only objection is relevance, it's admitted over objection. Next.
D3 is the May 10th, I guess, 2021 second police report from South Fulton, which the officer testified to.
Any objection?
No objection, Your Honor.
D4
Without
is
objection.
I'm sorry.
Go ahead.
D4 is the May 10th, 2021 warrant obtained at 3 a.m. by South Fulton police officer for the Rivertown Road incident.
Any objection?
Objection is irrelevant to the issue before the court, Your Honor.
Okay, admitted over objection. Next.
D5 is the actual bond order that's in effect for this case. We'd ask you to admit it or take judicial notice since it's a record of the Fulton County courts.
Any
No,
objection?
no objection.
No.
D7.
That was also the state's exhibit as well, so admitted. Next.
And D7 is the August 26, 2022 order of the Fulton courts modifying the bond order, which again would allow him to go on the property.
Any objection?
No objection to that, Your Honor.
Admitted. Next.
DA is the, again, for judicial notice purposes, is the DA transfer memo, which says that there's no felony committed in this case. and transfers the case to the solicitor's office.
Any objection?
No objection, Your Honor.
D9 is the final order on the TPO entered 7/13/2020. And the reason it's relevant, it shows that it self-expired on 9/12/2022. So the whole TPO has expired. That's the only reason that's.
Any objection?
Yes, it's not relevant to the bond hearing, Your Honor.
Admitted over objection.
And again, we do not submit D10. We do not submit D10.
Okay. Anything further, Mr. Refoff?
Oh, just that I think the record will show, I don't even put him on the stand, was that he's made every court appearance.
Hold on, I'm going to give you the opportunity to argue, okay? So I just want to get to your case. Are you done with your case?
Yes, we rest.
Okay, very good. Ms. Tortorella.
Yes, Your Honor. Your Honor, you heard testimony from Officer Carter of the South Fulton Police Department that proves the defendant's violation of his bond condition by being present at the 7945 Rivertown Road address on May 8th, 2022. Officer Carter testified on May 8th, 2022. He responded to that Rivertown address and he came in contact with the defendant who was actually at the address. Miss Norfleet testified that she came to her home to visit her son and observe the defendant's vehicle. The defendant was inside the residence on May 8th, 2022, which is a direct violation of his bond order. Your Honor, defense mentions the TPO order in the response to the bond revocation motion. However, the argument, Your Honor, is irrelevant. Regardless of whether his bond order contradicted to the TPO order, 2021 CV 349152, dated May 17th, 2022, the defendant was clear at his first appearance and when he received his bond on May 11th, 2021 of his special conditions of said bond, which included to stay away from the Rivertown address, regardless of what his TPO order stated. The May 17th TPO stated that he is to stay away from the victim's property if he is there for the purposes of harassing or intimidating the victim. The order also allegedly stated in paragraph 7 that neither was awarded sole and exclusive possession of the property because their son, Marcus Segal Jr., was the leasee at the property and either was able to enter said property by the invitation of the lessee. Your Honor, may I remind the court that though the TPO had an order under civil law, there was an actual bond order here under criminal law that was also effective and ordered the defendant to stay away from the Rivertown address. A TPO is when a petitioner has asked the court to provide a layer of protection in a civil context. While a crime may have occurred, the protection granted by a TPO is fully based in civil law, and there is not a prerequisite of an arrest. The special conditions of a bond flow against an arrestee when a crime has allegedly been committed. They exist during the predisposition portion of the case, and if they are violated, there are special charges that can apply. So again, we are not here for a TPO violation. We are here for the defendant's bond order violation, which flowed from his arrest when he violated his family violence order. This defendant not only came back to the property the day he was served the TPO order on May 6, 2021, when he was ordered to stay away, but he decided to intentionally violate his bond when he came back to the property on May 8, 2022, when the bond had not been modified at that time. The defendant, Your Honor, is here to violate the law, and there's nothing further here. We believe that the state has proved by preponderance of the evidence that this defendant has violated his bond condition that set day on May 8th, 2022. Nothing further.
Your Honor, Mr. Stegall had a good faith belief that he was allowed on that property. It had been fully litigated in the TPO. And the judge had decided that he had been misled by Mrs. Stegall and changed that portion and says, No, you don't own this property, Mrs. Stiegel. Your son has a lease there. He can decide. So the whole thing is built on this house of lies that she created. And if you look at the bond order, I mean, I don't want to argue technicality, but the bond order originally says you're not to harass, or, in a section other, it says SA 7945 Rivertown Road, South Fulton. Now, of course, we might know that and stay away. What does a layperson know about that? Again, he has litigated this in the TPO, and it says he can go there. In 3 months, and a couple of months after this order is entered, the bond order is clarified, and we put it in as exhibit D7, which did allow him to go on the property. Specifically, it was amended. D7 shows that did allow him to go on the property. So what we argued about a technical violation of a bond, if it occurred a year and a half, something happened a year and a half ago, it was superseded by another bond order and another 12 months TPO order. It's moot. Whatever that original bond said is moot on May the 8th, 2022. Because again, he had a good faith belief that he could go there because it said he could. All he had to have permission with his son, and we know he had permission from his son. And again, it may be my fault that the wrong name got entered. It's Trayon Stiegel who's mentioned in paragraph 7. It's not Marcus Stiegel Jr. He's the one. Trayon, who testified here today, is the one who said his father had permission. So, I mean, it seems to me like this is a waste of the court's time and resources. But we did ask the court not to revoke his bond. He's done what's required. He showed up. He's been in court. We'd ask the court not to revoke his misdemeanor bond. Your statute says you're entitled to a bond. And so we'd ask the court again not to revoke his bond.
All right, so I think I've heard everything that there is to hear regarding this. You have anything further that you want to say as far as your general and special demur goes?
No, Your Honor, except the demur, just short. It says that he returned to the residence of Tracy Stiegel. Well, the residence is the way the TPO, the judge in the TPO decided, was 5200 Cotter, not 7945. So there's no evidence in the accusation or any of the evidence the state has cited today that shows he ever returned to her residence.
What are you actually asking the court through your
to dismiss the case? That's what, if you grant a demur, it dismisses the case.
Anything further, Ms. Tortorella?
As far as the bond, Your Honor, or the mere motion?
Either.
We are going to make the argument that it was untimely. If I can proceed with that, Your Honor. And we also have a Corporal Fullerton from Southfield Police Department as to testify for the demur if it proceeds, if Your Honor doesn't find that it was untimely.
No, okay. Hold on. Anything further?
No, Your Honor.
Okay, so I'm not going to dismiss the case, so that's denied. As far as the revocation goes with the bond, I'm not going to do that either because this is very confusing. I think that everybody here understands that it's confusing. That yes, he was to stay away from 7945 Riverton Road, but then there's another order. This judge should have known that this bond was in place when he or she made this other ruling. So it's very confusing as to when he can be there, when he cannot be there. So I'm not going to revoke the bond. So I'm not revoking the bond. I'm not dismissing the case. Anything further?
No, Your Honor.
Okay. What I will entertain at this point in time is making this clearer if either the state or because now what's in what's in effect is this original that he cannot, that he has to stay away from the 7945 Rivertown Road address. It appears to me that the complaining, the alleged victim in the case is not at that address. The son is at that address. She says that it's her property. There's some testimony regarding who actually is who actually leases the property. She says that it's not her younger son, Mr. Trayon, but it was another older son who I did not get named in this matter. And although this TPO is not in effect, what is in effect right this second is that he can't go back to 7945 Riverton Road based on this bond, which has not been modified. Right?
No, the D7 is the order entered on August the 26th, 2022, modifying that original bond, which allows him to go on the property specifically. It says that.
Yes, Your Honor, that's correct.
Okay.
We were arguing that at the time of the violation had been modified, so therefore he violated the bond.
Okay, so the order for modification of bond is still in effect that was entered on August 24th of 2022. Anything further?
Nothing further, Your Honor. Can the state release their witness for the demurrer motion?
Yes. Anything?
Nothing further, Your
All
Honor.
right, you'll have a good rest of your afternoon.
Thank you.
I suggest that we have a number of cases that are on for the 1:30 calendar. I would like to begin right at 1:30. Call in those cases. I expect everyone to be ready to go in 10, 15 minutes. Let's get.
You're free to come. Okay. All right. Well, I'm the outside because I'm down here. Okay.
You need some water.
Just so you know, Your Honor, you're muted.
I understand that the court has received the request. Erica Marshall Story for the state. I was not sure of the court's ruling.
Okay. So let me go ahead and call counsel to do, final bills, see who is here. Orca, a bench trial calendar, 1:30 p.m. Position number 1, Jamel Dickerson.
Good afternoon, Judge. Frank Gaither from the Public Defender's Office. I was going to be taking that case over. Mr. Dickerson is present. We understand there may be an announcement.
Stand up.
Mr. Dickerson, thank you.
Yes, we have to.
Okay.
Is there a request that the court was?
No, I thought there was going to be an announcement from the state in this case.
Yes, Your Honor. My understanding was that the defendant was pro se. I CC'd him, but we no cross the matter, Mr. Dickerson.
All right, have you gotten the court that now cross?
I sent it to a litigation manager, Your Honor.
Okay, Mr. Dickerson, your case is very dismissed. With that further, you're free to go. All right, have a good afternoon, sir. Thank you.
And he was pro se, Judge. It was one of those situations where he fell through cracks. So he was pro se. He was pro se. He filled out applications. We didn't really know his status, so I was just going to take over if he needed a lawyer. So that's why I made the announcement.
Thank you. I appreciate it. Have a good day, sir. Mr. Number 2, Sergey Chap, GLEFPHCH.
Yes, Your Honor, that is the position that the state filed, the motion to continue based upon the officer currently being in stick for training this week.
Where did you find out that he was going to be in training?
Your Honor, I actually found out yesterday when I attempted to be prepared for the case and to prepare him for the case. And we received correspondence from our investigator Greer that this witness was in training.
What's the next? We set to March.
Your Honor, is the defendant in court?
He does not appear, but that's why I asked you if I saw that.
Yes, I personally reached out because he is not represented by counsel to see if we could resolve this matter. It was my understanding that he wanted to speak with the court and he would be in court. But I don't see him, so the state is requesting a warrant.
Okay, I'm going to grant you continuance. That was sought. I don't know if he received your, that's why I asked you if he received your continuance.
No, he did not, most definitely. And I am stating to the court that I called to try to see if this case could be resolved. So at that time, he had no idea whatsoever that the state would end up seeking a continuance. So I would really like the record to reflect that the defendant is not in court, not answered the call of the court, and that a warrant should be issued.
I'm not going to issue a warrant March 15th. If he does not show at that point in time and there's not a motion for continuance filed at that time, then I will entertain the motion. All right, so that was reset. We want the lead. Position number 3, William Hanson.
Your Honor, that case has been no crossed.
Mr. Hanson present. Position 4, Kelsey Walker.
Your Honor, yes, Your Honor, there was correspondence with the court earlier this week that the defendant had requested a jury trial.
Okay. Mr. Johnson present, attorney for Mr. Walker. Where is Mr. Johnson?
I'm not sure. I'm not talking this morning. You're saying that he's putting the out on their jury court, jury trial, but I don't know about it.
Yes, Your Honor. It's my understanding that it has officially been removed from your calendar because of the defendant's request for a jury trial. I think Ms. Redding is saying that might not be correct. We could not officially remove him from the calendar because the calendar had already been published. However, we did receive his waiver of framing, and I made sure I put it in the comments on the calendar.
Okay, understood. Thank you.
Well, I expect attorneys to be present in court to make the announcements themselves. So let your counsel know for next time, Mr. Walker, that's going to be, his jury trial is going to be in March. We're going to get a notice for sometime in March. Let him know that that you all will receive notice for jury trial in the March. Okay? All right. You have a good day. Board can see next trial calendar division 1, Juan Vidal.
Yes, Your Honor. I am present. Mr. Fidel Badrill is also present too, and Judge B already.
Okay.
Thanks, ready.
Okay, that'll be the first case.
And Your Honor, we have an announcement on Chronicle Bryant, position 1 on the Orca B bench trial.
Just right.
I'm sorry, Your Honor.
What could be the trial candidate, position 1, Nancy Ryan.
Yes, that will be a plea, Your Honor.
Mr. Brian is here, we're ready to move with the paperwork. Ready.
So you're ready to take a plea?
At your pleasure.
Okay, let's do that now.
Oh, would you smile your laptop? You know if you want.
Where you going to raise your right hand? You swear firm to testimony you give today the truth, the whole truth, and nothing but the truth.
Where?
That the speaking to my.
Oh. Where?
Put your hand down.
Okay.
Yes, it's still right.
Yes, Your Honor. This is State versus, I'm sorry if I butcher your first name.
Quanika
Bryant, case number 20 CR 003348E for the record. She's being charged with battery, family violence, first offense. The offer is 12 months or 3 days, credit from time served 3 days, balance probated, family violence intervention program, and no violent contact with the victim. And there's no objection to the defendant pleading under the First Offender Act.
That's my understanding of the agreement, Your Honor.
Ms. Ryan, it's my understanding of the case 20 CR 003348E. You went to plead guilty to battery, family violence. Is that correct?
Yes, sir. No, sir.
Counsel's representation.
Yes, sir.
You have to go to trial by jury on this charge, and then by pleading guilty to it, you're giving up your claim to a trial by jury.
Yes, sir.
Fourth, of course, you plead guilty.
No, sir.
Negotiated. I'm going to waive probation fees for you while you're on probation to help you stay on your feet. Is there any objection to that probation going on reporting once you leave the current?
No, sir.
From the state, yes, sir, she'll be pleading under the First Offender Act, so there will be an objection.
Okay, thank you.
Good luck to you, ma'am.
Thanks again.
And you'll get the paperwork with the probation department, information on it. If you can report to probation in the next 2 weeks, to get signed up and get started, okay?
Okay.
All right, any other questions, counsel?
No, Your Honor. I assume you want her to wait here till we get that paperwork, right?
Yes.
Okay.
All right, have a good day.
Thank you.
And Your Honor, for the Procedural case position 1 in Orca C, state's just waiting on video and audio, but for the most part, we're ready.
Okay.
Audio and video.
Are you going to make that presentation first, Ms. Tortorella? the video audio? Is that gonna be needed first, or you gonna have a witness before that?
I need to authenticate to the officer. So when the officer takes the stand, I'll authenticate and tender the video and then the audio. I can,
Okay,
I'm gonna tender it through the business certification exception of hearsay rule. I'll play it then, but I don't have it yet.
okay.
I have it, but they need to working on burning it.
And this is yours. Right here. Ms. Helen, have you seen the video?
I have.
Are you gonna have any objections to it?
No, Judge.
Okay,
Is it just one video or are they presenting all 8?
Ms. Tortorella. I just asked Ms. Helen if she's gonna have any objections to the video. She says no, but she's asking if there's just gonna be one video.
It's gonna be just to make sure we're all clear, there's 2 videos, involving Officer, Jay Thurman. So I'm gonna be playing those 2 videos. Just the 2 out of the 8 that I.
Okay, can I get the duration just so I can know which videos you're talking about?
Sure, let me look it up first.
So just for clarification, Ms. Tortorella, when you say not just yet, do we need some time for that, or can I go ahead and get the case started?
If Your Honor would like to get them started, I prefer, if it's Your Honor's pleasure, I prefer if, we prefer if it's maybe give us 10 more minutes.
Okay, I'll give you 10 minutes if that's what you need. So, is that all right with you, Ms. Helen?
That's all right with me, Judge.
Okay, so Ms. Tortorella, just ask me for what you need. Okay, so if you say not yet, that doesn't give me an indication, but I'm happy to give you some time if that's what you, if in the future, if that's what you need, okay?
Thank you, Your Honor.
All right, so we'll be in recess for 10 minutes.
Understood, Judge.
Okay, Madam Court Reporter, we're ready to go on the record. Court calls the case of State of Georgia versus Naquan Fadrell, accusation number 19 CR 009480F, charged with interference with custody. Would counsel for the state announce itself, please?
This is Maria Jose Portorello. Last name is Tortorello.
Ms. Tortorella.
Yeah, the mic is off.
This is Maria Jose Tortorello. That's Tortorello on behalf of the state.
And Ms. Helen, would you announce yourself and your client?
Yes, Your Honor, it is Attorney Catrice Helen appearing on behalf of Naquan Fadrell.
Okay, thank you. Are we ready to proceed?
Yes, Your Honor.
Call your first witness. Would you like to make an opening statement?
Yes, Your Honor.
Okay.
Good morning, or good afternoon, Your Honor. On November 24th, 2019, defendant Naquan Fadrell was arrested for interference with custody by the Atlanta Police Department. The incident occurred at 2:45 p.m. Officer Jay Thurman responded to the BP gas station at 2320 Shishai Bridge Road in Atlanta. On information, a child had been taken. Upon arrival, the officer met with caller and victim, Miss Victoria Powell. The officer learned that Miss Powell came from Florida with her baby, Giovanni Powell, to visit her uncle, Keith Davis. The defendant, who is the biological father of baby Giovanni Powell, came to see his son at Mr. Davis' home. The defendant arrived with his sister, Imani Fadrell, and his brother, Gene Fadrell. The defendant took baby Giovanni without Miss Powell's permission and did not return the child until about 10 hours later. Your Honor, the prosecution will call the victim, Ms. Victoria Powell, to the stand. The victim will share with you information about what happened that day and how the defendant took baby Giovanni without permission. She will also testify how she was almost dragged out of the vehicle by Imani Fadrell was driving. She will also testify on how she was almost ran over by Miss Imani as she backed up and sped away with the defendant and the baby inside the car. She will further testify to the many calls she made to the defendant begging him to return her child to her. She will further testify how she is the sole and primary custodian of her baby boy. And finally, she will testify to the fact that the baby was returned about 10 hours later. Officer Thurman of the Atlanta Police Department will testify to what he saw at the scene that day, his investigation, and how he came to the conclusion the defendant was interfering with custody, when an Amber Alert was issued, how there was numerous attempts to reach the defendant, and how the child was returned several hours later. Mr. Keith Davis, if present, will testify to the fact that he observed the defendant take baby Giovanni without the permission of Miss Powell. Your Honor, the defense may argue the defendant had permission to take the child that day. However, the state will prove that that was simply not the case. At the conclusion of the case, find the defendant guilty beyond a reasonable doubt, and that the state has met its burden of proof. Thank you.
Ms. Helen?
Yes, Your Honor. On November 24th, 2019, my client had already reached out to Victoria Powell, the alleged accuser, for permission for her to come into town at the location of Keith Davis's address so that he can visit with his son, who was 5 months at that time. That conversation has been screenshotted on Instagram messages that they had shared prior to this meeting. And so I believe that the evidence will show that the state cannot meet its burden today. Your Honor, if my story and our version of what the events actually took place, Judge, is equal to the state's version, they have not met their burden, Judge. It is beyond all reasonable doubt. And Judge, according to the statute of OCGA 16545, interference with custody, it is natural parents. And during this investigation, the officer showed that neither Miss Victoria Powell or my client showed proof of any type of primary custody. So Judge, we believe that we will be able to show that my client had permission prior to this event, and that Miss Victoria Powell, for whatever reason, got into an argument with the sister and believed that no longer the situation of them agreeing that he would have the child for an extended period of time was still valid. It still was, Your Honor.
Thank you. Call your first witness.
Your Honor, at this time, I would like to call Ms. Victoria Powell to the stand.
Would either party like to invoke the rule?
I'm sorry, Judge, what'd you say?
Would either party like to invoke the rule?
Yes, Judge.
Yes, the state will invoke the rules of sequestration, Your Honor.
Okay, if there are any witnesses that are in the court that are expected to testify, I'll need for you to wait outside prior to your testimony.
Officer Thurman, Your Honor.
Okay.
Right, can you please raise your right hand? You swear to affirm that the testimony you're about to give is the whole truth and nothing but the truth, so help me.
I swear.
You may leave your mask down while you testify.
State your name for the record.
Victoria Powell.
You can have a seat, Ms. Powell. If it's more comfortable, you can adjust the microphone. And can you spell your name for the record?
Victoriapowell.
And what do you do for a living, Ms. Powell?
I am a server at Tortugas for the kitchen and bar.
Was your child taken on November 24th, 2019, around 2:45 p.m.?
Yes, ma'am.
Who took your child?
Naquan, his sister, and his brother.
Did you give the defendant permission to take your child?
No.
What was that?
Yeah. I gave him permission to come see him.
Can you point the defendant out and state for the record what he is wearing?
Navy blue sweater.
Can you point him out for the court? And I'm sorry, may the record reflect that witness Ms. Victoria Powell has identified the defendant?
So reflect.
And how do you know the defendant?
We met in 2016 working together at Golden Corral.
Is there another way that you have some sort of relationship with him?
Oh, we share a child.
And what was the address at the time of the incident?
Mine or the
incident where your child was taken?
I don't remember my Uncle Keith's old address because he doesn't live there anymore, but it was the Gables in Midtown.
Okay.
Off of Monroe Drive.
So, okay, Monroe Drive, and is that in Fulton County?
Yes, ma'am.
Okay. And where do you currently live right now?
114 Lynbrook Drive, Palm Coast, Florida, 32137.
Okay. And was your residence in Florida in 2019?
Yes, ma'am.
Okay. So what were you doing at your uncle's residence that day? You said it was off of Monroe?
Yes, ma'am.
Drive. What were you doing that day?
I was up there visiting family, and Nan and I had talked about him coming to see Gio and all of that. So it was me coming up there for him to see his son and for me to come up there to see our family.
And what is your uncle's name?
Keith Davis.
Can you speak to the mic, please?
Keith Davis.
Okay. And around what time did you come over to your uncle's house?
I got there around 1 o'clock in early afternoon.
And did the defendant come over at any point?
He got there around 2:15 in the afternoon.
Okay. And why did he come?
To visit his son.
And did he come over by himself?
No, ma'am.
Who did he come over with?
His sister, Imani Fodrell, and his brother, Gene Fodrell.
Then what happened?
Gene disappeared briefly. And then...
Please speak to the mic, sorry.
Jean had disappeared briefly and we weren't thinking anything of it because like they're enjoying time with the baby and this, that, and the third.
And who is we?
Me, Naquan, my uncle Keith, and not really his sister. His sister was kind of like standoffish, kind of like off to her own self. But we didn't think anything of it, obviously. So I'm in the bathroom, and then next thing I know, I hear my uncle Keith yelling, "Hey, come get your Victoria, come get your baby daddy. He's trying to take Gio and he's not bringing him back." And I'm like, "Wait, what?" So I go out, I'm following them. I'm like, "Nay, bring Gio back." He keeps saying, "No, this is my son. You can't tell a father what to do with his child." And I'm like, "Naquan, the agreement was for you to come see him, not take him, bring my child back." So I follow them down to the parking garage. His brother and his sister are just trying to like keep me from getting to Naquan and Gio. And I still was able to like get out of the actual door to the car. Once I was able to like get slightly like somewhat in the car enough to like be able to reach over to Gio, I was dragged out of the car and by his brother. And then the car got in reverse. And as I'm trying to get back up to get back in the car was in reverse and she almost hit me.
Who is she?
Imani Fadra.
All right. And what did you do after you attempted to get your child out of the vehicle?
An innocent bystander who had saw the whole situation. I have no idea who he is, a good Samaritan. Saw the whole situation. He let me get in his car. We tried to follow them. We ended up losing them. He said he had somewhere else to be, so he dropped me off at the BP and called APD from there.
And is that the Shisha Road address? The 2320, the BP gas station?
Yes, ma'am. Yes, ma'am.
Did you call 911 at any point?
I believe I did and my uncle Keith did.
When did you call 911?
When I got to BP.
Okay. Then what happened when you got to the BP?
When I got to the BP, I called APD and then I don't know how my uncle Keith found me, but him and my aunt found me. They were already on the phone with APD as well. And then it was just more like a waiting game at that point. We kept trying to contact Naquan, like his sister, his brother. I ended up getting blocked by his sister and his brother. We even sent them a message on Instagram, like, you know, "Hey, do you know the time frame and you'll be bringing the baby back? And if that time frame isn't met, then the warrant will be issued for your arrest." The message we got back was IDC, meaning I don't care.
How long? So when did the police arrive? About how long did they arrive after you?
Maybe 30 minutes or so, not too long.
And then what happened when police arrived?
We all tried to contact the defendant and it was just a waiting game after that. An Amber Alert ended up getting sent out when we couldn't reach him or he wasn't bringing the baby back. So I ended up getting my son back around 11 something that night.
And when did he take him?
He took him around 2 late, like almost 3 o'clock in the afternoon.
How many times would you say you call the defendant, to your knowledge?
I don't know, a lot, at least 100, I'm sure.
At least what?
100, I'm sure.
Was he answering the phone?
No, but he would send texts every now and then.
Was the defendant ignoring your calls?
Yes.
How do you know he was ignoring your calls?
Because it would ring twice, go straight to voicemail, then it would ring 2 or 3 times and go to voicemail. It wasn't like a steady ring one time, go to voicemail, ring one time, go to voicemail. It was ringing in different.
Speculation. It's not speculation, Your Honor. She's stating exactly what she observed that day. As far as the telephone calls to her knowledge, she experienced that, Your Honor. So that's
overruled. She can continue.
Like I said, it wasn't like because you know how when you call somebody and it goes to voicemail one time. No, it was like ringing 2 times voicemail, then ringing 3 or 4 times voicemail, ringing 2 or 3 times voicemail. So I know he was declining my calls or just purposely ignoring them.
Did you attempt to contact his family members?
Yes.
Who?
Imani Fadrell and Jean Fadrell. We also tried to contact his mom. His mom had me blocked at the time. And his sister and brother also ended up blocking me during the case, but I was already blocked by his mom prior to the situation.
Were there other signs that he was ignoring all communication with you?
Seeing seen on Instagram messages and no reply.
Okay. And who has primary and sole custody of the baby Giovanni?
I do.
Can you explain?
His Naquan did not sign our son's birth certificate when he was born.
If you'll excuse me, Your Honor. Okay, I'm gonna hand you what has been marked for purpose of identification as State's Exhibit 1. And let me show, I just need it back, I'm sorry. 11. Do you recognize this item?
This is Giovanni's birth certificate.
And how are you able to recognize it?
Because my name is on the mother's name and the father's name is blank.
Does this photograph fairly and accurately depict the subject matter therein on the date and time in question?
Yes.
Has the photograph been altered or any deletions made?
No, ma'am.
Your Honor, the people offer State's Exhibit 1 for admission as evidence.
Any objection?
Judge, the objection is the relevancy of the birth certificate.
I have the real copy as well.
The relevancy, the birth certificate as proof from the Fulton County government of parental rights.
Your Honor, this is relevant as to the fact that the victim here had sole custody at the time of the offense, and therefore it is alleged, Your Honor, that he did interfere with said custody.
Admitted over objection.
What was that, Your Honor? I'm sorry.
Admitted over objection.
Thank you. Nothing, hold on a second. Just a few further questions. I'm sorry, Your Honor. With whom did the baby live then and now?
The baby lived with me at the time and the baby still lives with me now.
Did you ever tell the defendant he could take the baby from the house on the day of the incident?
No.
Did you and the defendant ever discuss him taking the baby from the house?
Did we discuss it? Yes, we did discuss it. And then I shared with him that I was not comfortable with it just yet because of prior situations. And we talked about it. I told him I was not comfortable with it. And he said, he seemed like he just said, okay.
Okay. How long did the defendant have the baby when he was taken?
Like 8.5, almost 9 hours, somewhere around there.
How old was the baby then?
5 months, almost 5 months.
Okay. And where is the baby now?
The baby is at home. with my mom
And where do you live?
in Florida. Well, he's in daycare, I should say, but in Florida.
And how did you get to Georgia that day?
I drove.
Okay. Nothing further.
Cross?
Okay.
Oh. On November 24th, 2019, you told my client that he would be able to come visit.
Yes.
I'm gonna say GP because he's still a minor. Come to see GP?
Yes, visit, yes.
Okay. When my client shows up, he shows up with his brother and sister.
Yes, ma'am.
The sister says something to you in the living room, correct?
Yes, ma'am.
What did she say to you?
She.
Objection, hearsay.
Understood. You have an argument with the sister.
Yes.
You're in the living room?
We started in the living room. I don't remember what the argument was about, but it had something to do with Nay and like the whole custody, not custody, but the whole Giovanni situation. Because like she felt like, Nay had the right to just take him and not really care about how I felt about it. But I have my reasons for why I was kind of hesitant back then on, the safety of my child. So.
And Imani offered you physical violence in the living room?
Yes.
She swung at you?
Yes.
You told the officers on November 24th, 2019 that Imani swung on you?
I don't remember if I told them that or not.
Can I show you a video?
My child. I don't remember.
Can I show you a video, Judge? Can we play that 3 hour and 9 minutes? I have the timestamp, but I would like to just show that video.
Objection, Your Honor. It hasn't been properly tendered into evidence.
Then, Judge, we would like to properly tender into evidence a video of 3 hours and 9 minutes and 15 seconds.
Can you properly tender it with this witness?
Yes, Judge.
Okay, then you have to lay a foundation. If you can lay a foundation, go ahead.
So on November 24th, 2019, you were at the BP gas station?
Yes, after you took my child, yes.
You called the police?
Yes.
And then so the officer shows up to that BP gas station?
Yes.
When the officer shows up, you're screaming.
Yes.
What are you screaming?
I'm upset that my child is gone and you're refusing to bring it back because that was not the agreement.
You screamed to the officer, "I'm going to kill him." Yes?
I don't remember. It was a rough moment. It was a frantic situation. I don't remember everything I said.
And so the officer that shows up, he's the first person that makes contact with you, correct? And so when you first make contact with this officer, you don't tell him that Imani swung on you.
No, because my child had just been taken. Why am I going to be thinking about that if I'm more worried about my child trying to be?
At no time did you tell the officer Imani physically tried to punch you, correct?
No, what does that have to do with him taking my child?
So when the officer shows up on his body worn camera, or at least in the interview with you, you state that you got a ride with a stranger to the gas station?
Yes, I did.
And that
a good Samaritan, if you will.
And that then your uncle and Charlene show up later?
Yes, Charlene is my aunt. Yes, ma'am.
And so when the officer shows up, he asks you, do you have any proof of any type of primary custody?
I say, I don't remember, but I believe I told him no, but he did not sign the birth certificate.
So you told the officer you did not have any proof of primary custody?
I believe I did, but I don't remember.
Hold on. Take it down a bit. I can only hear one person at a time. The court reporter can only take down one person at a time. So allow her to complete her entire answer.
Understood, Judge.
Ms. Powell, you can complete your entire answer, and then Ms. Helen will ask you the next question, okay?
And so I'll just repeat the question. You never told the officer that you had any proof of primary custody of GP?
Not that I can remember, no. I
Do you
don't.
currently now have any proof of primary custody?
Yes,
GP?
I have it physically with me.
And what is that evidence?
The birth certificate.
You don't have any other documentation from a Fulton County court other than the birth certificate?
There isn't one because if he didn't sign his son's birth certificate, how are we supposed to do that?
On November 14, 2019, did you tell the officers that my client? 14, 2019? Did you tell, you told the officers that my client was in the midst of a legitimization process in Gwinnett County?
That's what I was told by the defendant, yes.
And that this legitimation process was still underway?
That's what I was told by the defendant, yes. I lived in Florida, so I don't know what he's doing in Georgia at that time because he was up here. I lived in Florida. That's what he told me, yes.
And prior to this November 24, 2019 incident date, how many times had you allowed my client to come see you?
I had offered the opportunity to him multiple times. He only took the opportunity maybe twice.
And so in those 2 times, do you remember the date?
No.
But he did come visit GP.
When I brought him to Georgia, yes. If I would ask him to come to Florida, it would always be an excuse.
And Naquan Federal is the biological father of GP. So you would agree he's a natural parent?
He is the father of our child. Yes, he is.
You told the officers, or how about this? The officers told you they were going to give time to my client for him to come and bring GP back, correct?
Yep.
How much time did they give him?
They asked him for a specific time frame. They said, can you give us a time frame on when the child will be brought back? And if you cannot meet that time frame, then a warrant will be placed for your arrest.
On direct, you told the solicitor that you got at least at the gas station, the BP, about 2:30?
Yes.
Do you know when the officer submitted the Amber Alert?
It was around 7, 8 o'clock that night.
You believe it was around 7 or 8 o'clock that night?
Somewhere around there. It was like evening. Yeah.
And on this date, you told the officers that you were following behind a gray vehicle?
Yes, it was a gray Jeep.
Okay. On November the 24th, 2019, my client, to your knowledge, lives at 3281 Terry Ashley Lane.
Snellville, yes.
Snellville. And you lived in Lawrenceville prior to moving to Florida?
Yes, ma'am.
And do you believe that my client was headed with GP to his home address?
I did not know where he was going, but given the fact that the way that they strategized it, I didn't assume because that would have been like, okay, they're going to follow me straight to my house. So me initially, no, I didn't assume he would go straight to his house.
Did you ever offer my client the option of picking up GP from Keith Davis's house and keeping him to November the 27th?
We did speak about that. And I asked them I told him, if you can be consistent and see your son 5 times due to prior situations, like abuse situations, that was going on while I was pregnant with Giovanni, that he could take Giovanni, but I needed to feel comfortable and safe with the fact that he wouldn't be frustrated and take his frustration out on the baby like he did when I was pregnant with the baby.
Did you say yes?
Yes, we talked about it.
Okay. Did you give him the permission between
Not
November
spoke
the
permission,
24th?
spoke about it, not
Only
spoke
spoke about it?
permission.
So at no point did you tell my client it was
Not that I
okay
can
to have
recall.
him to the 27th?
Not that I can recall, no.
Give me 1 second, Your Honor. The officer told you that Gwinnett Police Department would do a welfare check on that Ashley address?
I don't know, a welfare check on Giovanni?
On the address, yes, the Ashley Lawrenceville address?
I believe they did say that they would go check there, yes.
Okay. Did the officer ever tell you that, hey, they already showed up to the house to make that check?
I don't remember if they said that or not.
At any point, were you threatening towards any officers on scene?
Was I threatened?
Threatening towards any officers on scene?
That was not threatening. I was an angry, upset person who wanted to get her child back, but I don't believe I was threatening anybody, no.
Did you ever apologize to an officer saying, hey, my uncle said that I came off threatening, I apologize?
Objection, relevance.
I think it's relevant to the case, Judge, and also to the video, putting up a foundation about Miss Victoria Powell's demeanor when the officers arrived to report.
Would anybody be happy about their child?
Hold on. Don't talk unless there's a question posed.
Understood, Judge.
Not you, Ms. Helen. Okay, overruled, continue.
Understood, Judge. And the entire, from November to 24, 2019, where was the baby? Where is GP? Who had him this entire incident?
The entire incident, what do you mean, of the day that the incident happened? I brought Giovanni up from Florida. His father took him, so I don't know how you want me to answer that
In
question.
the apartment, who has Giovanni in their hands? Who has him? Is he in a?
Both of us.
Okay. Are you in a back room at any point speaking to my client?
I'm sure we probably were.
Was the baby with you guys?
I don't remember. The baby was at the house. I don't remember, but the baby was at the house for sure.
How did the baby get outside to the gray vehicle?
Naquan physically took the baby to the car.
Naquan Fredero, my client, has control, possession of the baby the entire time?
Yes.
Who's driving the gray vehicle?
Imani. Gene, so we figured out Gene is the one when he disappeared. He went to go get the car and then came back. No, he was waiting in the car and then came back and then got out when he saw me down. And then Imani got in the seat. And then Gene, when I'm in the car trying to like reach to get Giovanni or GP, I got dragged out of the car. And then when I'm like trying to get up, the car is in reverse and I almost got hit.
And you told the officers that Imani?
No, I did not tell the officers that.
But you did tell them that Imani swung on you?
I don't remember if I told them that either.
Understood. No more questions.
Redirect.
Yes, Your Honor. Has the defendant ever legitimized Giovanni Powell?
No.
You testified before that you came to the BP gas station around 2:45 p.m. Is that accurate?
Yes, ma'am.
When did you have that conversation with the defendant about him being allowed to take the baby?
Him being allowed to take the baby? What date did she say? It was like a November 14th or something. It was like 14. What? So I'm assuming that had to have been.
I'm not sure that's, I think, I can't speak for what she said, but I'm asking you, when did you talk to the defendant about how many days before the incident?
He brought it to me that if he could have Geo for a week, and I said, we'll talk about it. I don't feel comfortable right now, but we'll talk about it. If you can come see your son 5 times and, you know, work past the whole abuse stuff that I'm was, you know, traumatized by, then yes, you can take him.
And what did that conversation, go ahead.
Those statements about abuse, the judge, I'm just gonna say speculation.
Your Honor, it's not.
I have proof. I have hardcore proof.
Ms. Powell, it's not speculation if it's coming from the victim's experience, Ms. Powell's experience, if that's what counsel's trying.
I don't know what that has to do with the interference of custody. I think it also might be more prejudicial than probative. If you can establish how it's relevant to this interference of custody on this date, then I will allow you to go into it further. If it's not relevant regarding this matter, then I'll give it to us a little bit. Sorry.
The state would argue that because of her personal experience with the defendant, that was the reason why she did not allow or does not allow the defendant to have the baby.
Okay, and I think that you have made that point. She's testified about it. I've heard it. you can move on.
Okay, so I'm trying to still get a clear time frame about that conversation where you said if that you testified to about him.
We'll say, so she said November 14th, we'll say about a week and a half prior to
the incident.
Yes, ma'am.
Okay. Did you change your mind at any point in time between that date and November 24th, 2019?
About
Him taking the baby?
Change my mind? What do you mean? Like, did I say yes and then say no?
Correct.
I'd never fully said yes. I said we would talk about it.
Okay. So you never agreed?
Never
that he'd
fully
take
agreed.
it? Okay.
No, we talked about it.
Did he ever ask you, well, let me go back. You testified that you called the defendant 100 times that day after he took your son. Is that accurate?
Yes, ma'am.
How were you feeling when you were calling those 100 times?
I was more like scared for Gio than anything. Because like he, had like certain like medicine, not medicine, but it was like he had eczema. So like I was making sure that he was fed on time. He didn't have any like diapers. They just took the baby. They didn't have anything with them with the baby. They just took him. So I was more concerned about the safety of him. Making sure that he ate because he was breastfed at the time. And like they gave him water. Like he was spitting up water when I got him back. He wasn't drinking water at that time. He wasn't changed. Like I was scared. Like I was distraught. I was like terrified. Like, where's my child? Like,
all right, nothing further. Oh, sorry. Did the defendant have, to your knowledge, formula with him?
I don't
with
know.
the baby?
No, when they arrived, they didn't have anything with them. And when I was like trying to get Gio out of the car, I didn't see any diaper bag of any sort in there.
Was he strictly a breastfed baby at the time?
At the time, yes, ma'am.
So he's strictly a breast from, okay. Did the defendant have any diapers to your knowledge at that time?
My knowledge, no.
And to your knowledge, did the defendant have any cream for his eczema?
No.
Okay.
Nothing further.
Okay, thank you, ma'am.
Recross.
Okay. Okay, go ahead.
Thanks, Judge. Ms. Powell, you've never reported that my client has ever caused or offered you violence.
There's a whole police report about it when I was 8 months pregnant and he left us in the hospital, and there's even messages of him admitting it. And there's bruises. There's a whole police report.
And there's a current case against my client where
There's not an open case about it, no.
My client has never offered any violence to GP ever.
What do you mean?
My client has never.
He definitely did though. When I was dragged down the stairs and hit my stomach pregnant with Giovanni on the corner of a couch, yeah, that caused harm to Giovanni. Him physically being on this planet and being in my belly, there's no difference. He still physically caused harm to that baby. He did not care.
You've never reported to the police?
I did report it to the police. The police were called.
There is a current open case.
Not currently right now, no.
But there is no case against my client right now alleging any violence towards you?
Not right now.
Objection, Your Honor. This again, relevance.
Well,
We just got.
I made my ruling on it. Ms. Helen opened the door for her to talk about this. If I wouldn't have opened the door, if I were you, Ms. Helen, but now that you've opened the door, she's gonna be able to walk through it and I can hear whatever she has to say. about
Understood, Judge.
the violence there was. So I don't understand. I'm gonna allow her to testify about
That's
this.
fine, Judge, but
But If there's an objection from the state.
No,
then-
not your honor.
Okay, what would you like me to answer?
The question was, currently, there is no open case.
Currently, at this moment, no, there's not an open case.
That's it, Judge.
Okay. Thank you, ma'am.
Okay, am I free to
Unless somebody else has anything else.
my respective bench?
Have a, you can step down. Thank you, ma'am. Call your next witness.
Actually, your honor, at this time, under the hearsay exception rule 24, OCGA 24-9-902, business record certification, we would like to tender the 911 audio into evidence. A.R. Nelson, and for the record, an authorized custodian of records for the Atlanta Police Department Emergency Call Center, hereby certifies that A.R. Nelson had personal knowledge of business filing record system of the business known as Atlanta Police Department 911 Emergency Call Center, located at 226 Street Southwest, Atlanta, Georgia, 30303, and having reviewed the attached business records describes as follows. The 911 Emergency Call Center reporting associated with Atlanta Police Department Incident 19-328-1196. Your Honor, the record was made at near a time of the occurrence of the matter set forth from the information transmitted by the person of knowledge, which is A.R. Nelson, the custodian of the Atlanta Police Department 911 Emergency Call Center. The records were kept in the course of the regularly conducted activity of the above named business entity, and the records were kept in the course of regularly conducted activity as a regular practice. So therefore, Your Honor, the state would like to tender the 911 audio under the exception stated as State's Exhibit 2.
Any objection? Any objection?
No objection. No objection.
Admit it without objection. Did you plan on playing it now, Ms. Tortorella?
Yes, and the business record certification will be State's Exhibit 3, Your Honor. They don't like you can like share screen and. So. Fine, she says. When they play that 3 hours, watch how bro the judge. That's it.
Oh. Everyone's gonna have to turn their mic off.
I don't know why it keeps turning back on. You see? I don't know. They wouldn't let us through.
You have to, yeah, the other deputy showed me it was a trick. Yeah, you have to. It's just.
Atlanta 911 operator 7571. What's the location of your emergency?
These people kidnapped my son. They kidnapped my son.
Where are you?
They kidnapped my son.
Where are you?
Where are we? Where are we?
On Chester Bridge.
On Chester Bridge Road.
Okay,
They kidnapped my son.
Okay, ma'am,
They
give
kidnapped my son.
ma'am, give the phone to somebody else. Give the phone to somebody else. Ma'am, can you give the phone to someone else, please? Ma'am, I need you to give the phone to somebody else, please. Sir, can you take the phone from her, please?
Okay, yes.
Okay, sir, you're Cheshire Bridge and where? What's across street?
Oh my God.
Okay, the corner street. I'm sorry, miss, give me 1 second. It's going to be, it's a Vista Road. Pretty much, I'll leave it right here.
I'm sorry, sir, I cannot hear you. You're Cheshire Bridge and what's across street?
It is Lindbergh Drive. At the DP right here.
Cheshire Bridge and Lindbergh?
Yeah. Okay, listen, you know what?
At BP.
Listen, it's time to go because, listen, miss, okay? And to have the temporary tag number as well, too, it's going to be S as in Sam, and that's going to be 0188, and that's going to be 384. And that is a CarMax temporary tag.
Okay,
and that's all information I have.
Sir.
It is a Jeep.
What color was the Jeep?
Yes. It is silver. It's silver, and it's a 5-year-old boy. And
5 months old.
Okay, I need you all to hold. Slow down, just slow down. We have a silver Jeep with the tag number of S0188.
I apologize, Your Honor. Hearsay. With respect to the caller.
Did you hear this before today?
Yes, I provided the audio to defense.
Okay, it was admitted without objection.
And-
That rule stands.
And we provided it in discovery as well, Your Honor, and it's been admitted through the hearsay exception.
Okay, overruled. We can hear the rest of it.
384, is this correct? Hello, sir. Hello, sir. Hello?
Let's go inside, okay?
It was a silver Jeep. What way did they go? Did they leave?
Oh, yes, hello?
Hello, we got disconnected. What direction did they leave?
Okay, so pretty much they went, I'm not sure if they went south or north onto Monroe. Because pretty much hit her up, from the scene because it was like 4 people and she was fighting them and they were like beating her up. So I had like no idea as to what was happening. And pretty much if they have the kid in the car and they're gone with the kids. So I didn't know if it was like a family dispute, if it was a custody battle.
No, I understand. I'm already getting officers en route to that location. Can you give me a description of the mother so the officers know exactly who she is?
Yeah, sure. It is a young black lady, and she's wearing some black tights, and I believe a white shirt, and she's very distraught. But I have no idea as to what's going on. So I can't have her in my car anymore. She's, like screaming and yelling. So I have no idea what's going on. So I can't be too much more involved in that. But so if you go to the Gables Midtown, I did see them. It is assaulting her there. I mean, it was like 4 of them, and they were, working her over, and she was fighting, as hard as she could, but I had no idea as to, what was happening. I didn't know,
Okay, I understand. Can you tell me if the men were black, white, Hispanic, or Asian?
Yeah, so pretty much it was a black guy wearing some shorts. It was a tall black lady, about maybe 6 foot, and there were 2 more people in the car. And they came out of the exit at the Gables on the exit of the Gables that is opposite from the leasing office. And they were in a silver, it is Jeep with a CarMax tag. And for sure, I mean, they were beating her up very badly, and she was fighting, but I didn't know what was going on. So I didn't want to, get involved and then get shot or something. So I didn't know. So I had her get in the car with me. I tried to chase them down, but they were gone.
Okay. We're getting the police out there now, man.
Yeah,
Thank you so
please,
much.
because this is nuts. Okay.
We're getting police out there. Thank you, sir.
Okay, miss. Thank you. Bye-bye.
Go ahead, Ms. Washington.
Okay, the CAD, you already were notified on it, correct, with the missing 5-month-old? Yes.
Y'all got some additional, because I see the units pulled out on this, so what's going on with it?
So apparently the lady was in a fight with, I got 2 of the driver's description was in a fight with them, and then they took off in a Jeep with the 5-month-old.
So it sounds like domestic, yeah. Okay, thank you, ma'am.
You're welcome.
Is that it? That's
I'm sorry, there's an echo. Yes, that's it, Your Honor. I think that's it for the 911 audio.
okay. Call your next witness.
Your Honor, at this time, the state calls Officer Thurmond from the Atlanta Police Department to the stand.
Okay. We need to have someone get him. Oh, okay. I guess.
Thank you.
Oops. Oh, no, I've asked you to do that. So thank you. Thank you for doing that for me.
Third, please raise your right hand. You swear to affirm that the testimony you're going to give is the whole truth, and nothing but
Yes, sir.
Please introduce yourself to the court.
Yes, ma'am. I'm Officer Jay Thurman with the Atlanta Police Department, Zone 2.
Can you spell out your name?
Yes, ma'am. First initial J, last name spelled out THURMOND.
Thank you, officer. How are you employed?
I'm sorry,
How are you employed?
with the Atlanta Police Department as an officer,
And how long have you been employed as a police officer in general?
approximately 5 years.
And with Atlanta Police?
Yes, ma'am.
Same. How many hours are required for your post certification?
I believe 40 hours. My post certification? I can't recall.
It's not 408.
408? I can't read. My post certification?
Yes. To get your, how many hours do you need to get your post certification? Are you post certified?
Yes.
Thank you. Were you post certified on the incident date of November 24th, 2019?
Yes, ma'am.
How long have you, already asked that question, sorry. Have you had any training on investigating interference with custody cases?
I do not believe so, no, ma'am.
Experience responding to those?
I've responded to a few of them over the years, yes, ma'am.
Okay. How many have you think you've responded to about in your career?
No more than 10.
So would you say you have experience investigating these cases?
Yes, ma'am.
At or about 2:45 p.m. were you on duty?
Yes, ma'am.
Were you in uniform to include your badge?
Yes, ma'am.
Were you in a marked police vehicle?
Yes, ma'am.
Did the incident involve the defendant, Mr. Naquan Fadrell?
That is correct.
Are you able to identify him?
I am not, no.
Huh?
No, ma'am.
You're not able to identify the defendant?
Yes, ma'am, I am. I'm sorry.
And can you identify the defendant in the courtroom?
The gentleman's sitting at the table.
Can you, what is he wearing?
Blue sweater.
Okay. Let the record reflect that the police officer has identified, Jay Thurman has identified the defendant.
So reflected.
Were you dispatched to the BP gas station at 2320 Cheshire Bridge Road in Atlanta, Georgia?
Cheshire Bridge Road, yes, ma'am.
Sorry, Cheshire. Were you dispatched on November, I believe it was 24th, 2019?
Yes, ma'am.
And is this a location within the bounds of Fulton County, Georgia?
Yes, ma'am.
What did you observe when you arrived at the scene?
Upon arriving on scene, I met with the caller, Miss Victoria Powell. I've learned through the investigation that Miss Powell was in town visiting family members. Mr. Naquan, the defendant, was also at the location during the visitation. There was a verbal altercation that ensued between the family members at the location, and at one point, I learned that the defendant took Miss Powell's child from her without her permission and drove off from the location with that said child.
Did you speak to the victim, Victoria Powell?
Yes, ma'am.
What were your observations when you saw Miss Powell?
Initial observations, she was visibly upset.
And what were you dispatched at the incident location for?
For a child being taken.
Was there any indication that the defendant was going to return the child?
Multiple chances were provided through telecom communication, to my understanding, and it did not seem to be so.
Okay. Was the defendant responsive to Miss Powell when she was calling him?
Not to the point where we could get an understanding of where the child was and the safety of the child. Current status of the child, on correction.
Did you call the defendant at any point in time?
I believe I made contact through Miss Powell's phone.
Okay. When you said made contact, were you able to speak to him?
I don't recall directly.
Do you remember about how many times Miss Powell called the defendant in front of you?
I cannot give a specific number. No, ma'am.
An estimate? No.
No, ma'am.
Did your department give the defendant a certain amount of time to return the child?
Can't give a specific time frame, but I was on scene for a very extended amount of time due to the nature of the call.
Right. And what was that? Can you explain about how long?
I believe over three to 4 hours, I believe I was on scene.
Okay. Was there any sort of alert issued that day?
That is correct. An Amber Alert was issued.
What information did you rely on to issue the alert?
The statements provided to me, and this collective knowledge was relayed to the Special Victims Unit, where they authorized that alert to go out.
How long had the child been missing at that point when the Amber Alert was issued?
I would say over 3 hours at that point.
Did you turn over the investigation at a certain point in time?
That is correct. The Special Victims Unit headed the investigation on the back end.
Is this typically what happens in these types of cases?
That is correct.
And why is that?
The Special Victims Unit they dedicate investigators to deal with incidents of this nature on a daily basis, and they have the tools and resources to pursue that investigation at a better capacity.
Okay. Can you explain a little bit more about that Amber Alert? In general, what is its purpose? Why is it issued?
Its purpose is to notify all local law enforcement agencies and the general public of the child that is in hand, that is missing. Typically, Amber Alerts are issued due to the nature of the child and how they went missing. Typically, this would be done by a non-authorized, being taken on without authorization from the primary custodial parent or guardian.
And the incident location at, I'm sorry, let me look at my notes. The BP gas station at, you said it was Cheshire, right?
Cheshire Bridge, yes, ma'am.
Let me get your address. At 2320 Cheshire Bridge Road in Atlanta, Georgia. What county was that in?
I'm sorry?
What county is that in?
Fulton County.
Okay. Were you aware of the child was in a car seat when it was taken, the baby?
I can't recall the specifics on the on that.
Okay. Let me go back, I'm sorry. So, was a defendant arrested?
Yes, ma'am.
Was he arrested that day?
Yes, ma'am.
Are you equipped with, were you equipped with your camera on your person that day?
Equipped with what, I'm sorry?
Were you equipped with a camera on your person that day?
Yes, my department issued body worn camera.
Okay. Is it routine for a police officer to have a body worn camera on his person?
That is correct.
How does a body worn camera operate?
Typically, it's either manually activated or activated by equipment that's turned on and should stay on during the duration of the investigation.
Okay. And how do you turn on that body worn camera?
Typically, you would double tap the center icon in the middle of the camera in the front.
And what does the camera record?
Records anything in front of the officer.
Did your camera appear to be working normally on the day in question?
It did, yes, ma'am.
Who loads and unloads the tapes?
I believe Axon oversees all that.
And what is with the tapes once they're full or no longer used?
I'm sorry?
How are they stored, the tapes?
How many stored?
How are the tapes stored?
Oh, through a database online. There's virtual servers, I believe.
When did you last view the body worn camera footage?
On today's date.
Okay. Are these the tapes that have the incident that occurred on November 29th, 2019 that involved the defendant?
Yes, ma'am.
Are the videotapes a fair and accurate recording of the events that took place at the beginning of your involvement with this case?
Yes, ma'am.
Your Honor, at this time, the state requests to tender in the body worn camera video as state exhibit 4.
Any objection?
No, Judge.
Admit it without objection.
Thank you. can be played. Is, and a couple more questions for you. 1925 Memorial Drive, is that in Clinton County?
Yes, ma'am.
Did you know the location from which the child was originally taken?
Yes, ma'am. That was relayed to me.
Okay. Nothing further for this witness from the state. We do have the cameras, the video, Your Honor, so I'm not sure what.
Okay, I'll have cross of, yeah.
Yes, I did.
Good morning, Officer Thurman.
Good morning.
You're the reporting officer,
Yes, ma'am. Officer Thurman.
and you've been working with the Atlanta Police Department for 5 years.
Approximately, yes, ma'am.
In the 5 years, how many interference of custody cases specifically have you dealt with?
I cannot recall the specific number, ma'am.
Would this be the first interference with custody case on November 24th?
I wouldn't be able to recall that.
Understood. Have you seen my client, Raquan Federo, prior to today's date?
No, I do not believe so.
Now I'm going to talk about what occurred on November 24th, 2019. When you arrived on scene, Victoria Powell was clearly and visibly angered and upset.
I'm sorry, I didn't understand the question.
Was Victoria Powell clearly visibly angered and upset?
Appeared to be, yes, ma'am.
She was so upset that you had to put your handcuffs on her to restrain her and calm her down.
That is correct.
During this initial interview at the BP gas station, Ms. Powell cannot produce any evidence or any court document that she's the primary custody, that she possesses primary custody.
I do not recall. I do not believe so.
At any point, did she offer you a document showing that she had primary custody of GP?
I do not believe so.
Victoria Powell called the police,
That is correct.
and when you arrived, she was screaming, "I will kill you," to a phone.
Okay.
I'm asking.
I do not recall a specific statement that she provided on scene.
During your initial investigation with Victoria Powell, she never states Imani Federo physically touched her.
Who?
Imani Federo, the sister of my client.
I don't recall a specific name.
During your initial investigation, Victoria Powell never states anyone makes any physical contact with her.
I do not recall.
Victoria Powell didn't have any visible injuries when you arrived on scene.
No, ma'am.
Through your investigation, were you able to find out what caused the argument at the original location?
I do not recall the specifics if I did.
Through your investigation, Victoria Powell was coming from Florida, that she didn't live in Georgia.
That was what was articulated, I believe.
Victoria Powell gave the address of her uncle so that my client could come see his child on that date.
I do not recall how they encountered each other.
Are you aware that my client was given permission by Victoria Powell to visit that address, to visit his son, GP?
No, ma'am.
Are you aware that my client is the biological father of GP?
That was stated to me, yes, ma'am.
According to your investigation, did Victoria Powell offer any violence towards anyone? Her uncle or my client, did she offer any violence towards anyone on that scene?
I don't recall any specifics or who they would have been directed to.
Give me 5 seconds, Your Honor.
Okay.
Do you recall the time that you arrived to the scene?
Yes, ma'am.
Would you agree that time was after 2 p.m.?
Like the overall time?
Yes, when you arrived to the scene.
No, ma'am, I do not know the time of the day without recollection.
According to your investigation, when was the child returned to Victoria Powell?
I believe, to my understanding, it was later in the evening.
Do you know how much later?
I do not know the specific time frame.
Are you aware that my client was given extended permission to be visiting his child GP from Victoria Powell?
That was not disclosed, no, ma'am.
Understood. No further questions, Judge.
Any redirect?
No redirect, Your Honor.
Do we need this officer for the video, or can he be excused?
Can I do one? I apologize. Are there any alterations or material changes to the video?
Not to my knowledge.
Thank you, Judge.
We would like the officer to stay in case there's questions after the video is viewed. The videos are viewed.
Okay, would you like him to remain sequestered?
I believe so, Your Honor, yes.
Okay.
Thank you.
Thank you, sir. We'll get you out of here as soon as possible.
Yes, sir. No worries.
Thank you, officer.
Your Honor, respectfully, actually, it is the officer's, it's the officer's video, Judge, so he's it's part of his presentation of testimony.
Yeah.
It's his evidence. Yes, so we'd like that he still be at the witness stand. If you'd like, Officer, Your Honor, may he sit down?
Yes, please. Are we gonna play the video now?
Yeah.
Peace. In Your Honor, I just have a question. Does the state intend to play the full 3 hour and 9-minute and 15-second video, or are we slicing it to specific moments?
I think if there's nothing relevant we could skip over, I would agree to that. If there's the videotape shows like the officer in his car or something like that, and there's nothing else to see, we could kind of fast forward a little bit to.
Well, you show whatever you want to show of it.
Okay. I understand. Okay.
You sure you don't want to stay?
Your Honor,
Can there's some feedback.
Can the video that was taken during the day be played instead of that one? Can we fast forward that one?
Do we need to mute these microphones?
Yeah, I was gonna say. You might mind. Yeah.
So there's two, I'm not sure. What's
The other one would be the date.
And Judge, I just want to make a statement. I thought the state was showing the initial body cam video. That video is the second video after the investigation had already essentially been completed. So I'm trying to find the original 3 hour and 9 minute video, 15 second that I thought the state was referring to, which is the initial investigation. So I'm just going to find that. But Judge, I do object to whichever video this is. That's not, I don't believe that's on the agreement. Yeah, too.
Yeah. So it's 15 part that we're gonna. And I showed you on this laptop.
That's not the video, Judge, and I just want to verify I have all 8. The one that was 3 hours and 9 minutes and 15 seconds is not that one, so I'll just go double check in the records.
Yeah, educated it, your honor.
It's I've already admitted it, so, there's an objection to this edit of objection. I don't know what we're seeing.
Just looking good.
And while we're waiting for the state's videos to play, I'd like to turn over to Ms. Bolton to present to the court state's exhibit number 1, which is the 911 call that was previously admitted and published. Ms. Helen, could you look at some? And Judge, I must have done to turn it on, but if you is, I don't know why it's that.
Can we figure out, why can we figure out what we have to say? I got to know this one. It's not.
Yeah.
Is there sound on the video?
No.
The audio wasn't cut into.
We don't have to choose any normal cars. Is there one car out here? It's still around. Or the cars that you mentioned. Okay.
Ma'am, 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 calm down, calm down.
I'm gonna kill him.
Relax, relax, relax.
I'm gonna kill him.
Relax.
Get me out of these cuffs. Get me out of these cuffs.
Relax.
I want outside.
I got you.
Stop. Get me out of these cuffs.
Stop. Victoria, stop. Put the car. 11 to radio. I have one black female detained.
They have my
No,
son.
I can't do that.
They have my son.
Ma'am, you need to calm down.
He's trying to talk to you.
I'm trying to help you, but we're doing all this. Sit down on my bumper. Sit down on my bumper.
Just be calm.
Take a deep breath.
Just calm.
Take a deep breath.
Listen.
Take a deep breath.
You can do all that after you get your baby, okay? Right now we need to figure out where he at. Who gives a fuck about your phone right now?
Stop.
I have my. Let me call. I have my.
Ma'am, stop. We're gonna get the baby back, okay? We're gonna get the baby. Calm down.
I want all pressed. I want all charges pressed. All charges pressed. Get me out of these cuffs.
Victoria, stop.
Get me out of these. Please.
Ma'am, ma'am,
I got you. Trust me.
you gotta take a deep breath.
Trust me, stop.
If you can't tell me what's going on, I can't help you.
I'm gonna kill him.
Calm down.
I'm gonna kill him.
Calm down.
I'm gonna kill him.
Calm down. Your mama said calm down. Calm down.
How am I supposed to calm down? He has my son has these
No,
fucking handcuffs on me.
Stop. Stop. Calm down. I'm here with you. Just calm down. I'm here with you. Okay? I'm here with you.
I'm gonna kill him.
I'm here with you. I'm here with you.
So, ma'am, what's going on?
Tell him. Be calm. Just tell him what happened. Just tell him what happened. Calm down. Calm down. Tell him what happened.
They came to see my son.
Who is that?
His dad and his dad's siblings.
Okay.
I said
Came where?
to his house to see him.
Okay.
To see him. He has been asking me, can he get him for the longest? I keep saying no because he has not seen you since he was 3 weeks old. He does not know you.
Okay.
He does not know you. I kept saying no. His name's not even on the birth certificate. So he has no rights to tell me what to do with the child I've been taking care of on my own. No rights.
Okay, so we all met at his house?
Yes.
Okay, and then what happened?
And me and his sister got into it. She got confrontational.
Okay.
And then next thing I know, they outside the building. And then I get yanked into the elevator. Next thing I know, I'm swinging, trying to get my son out of Naquan's arms, and they're in the car and they're gone.
Where is home? Where's your home?
Where the Gables in Midtown.
It's pissed off me.
Midtown?
Yeah.
How did we end up from Midtown to
I don't
here?
know.
How did we get here, man?
A stranger took me, followed me when they saw Navy, my baby, because I lost my temper.
Okay, so you're the baby's father has a child? Yes?
Yes.
Yes.
But
Okay.
it's not his legal, biologically yes, but legally no. He's not even on the birth, he didn't sign the birth certificate. He didn't want shit to do with his son. Now all of a sudden you want to
Okay,
come take him.
how does that work? But it's his son?
Yes.
Okay.
But he has not done anything to help me with his
yeah, I get all that.
He took the child
without permission.
Without consent.
Yes. He kidnapped my son.
He took it out of my house, and I told him to bring it back in, and he just left.
Okay, I got you.
I want all charges pressed. Anything you can press him with, I want it.
Okay, what's your address here?
Get this cuff off.
Man, if you promise to sit down, I can take the cuffs
I
off.
can't promise you that.
And then I can't take the cuffs off. You're acting erratic right now, and I'm trying to help you.
I'm supposed to act calm.
And I'm trying to help you. I'm trying to help you.
Victoria, they'll pay the phone down. So what we do? Get the baby in the car, and let me talk to him. Okay?
You want to do that?
I cannot help you. You're right. Let him take the cuffs off and take him back. We're gonna take care of this. I'm gonna get him.
Turn around.
I'm gonna get him for
Turn
you
around.
because he
I'm
took
gonna
my
take the
baby.
cuffs off.
He took my baby out of my house without my permission. Okay?
Okay, ma'am, you gotta let go of your hands.
Let go.
You gotta listen to me, ma'am.
Calm down.
Okay?
Calm down.
But all this isn't gonna help the situation. We gotta keep clean heads prevail, okay?
We're gonna get him. We're gonna get him.
I want him in jail for life.
We're gonna get him.
You put her in your car?
Yeah. Come on.
What's your address, sir?
1925. Monroe Drive. I'm apartment 16.
1945. It's the Gables in Monroe.
1925?
It's 19 Gables.
Okay.
I think it's like
1925?
I just moved there recently.
Okay.
I think it's 1945. Yeah.
Okay. So how does that work?
So
He's the father, though.
So they've been in litigation because he's had some issues with domestic violence and that kind of stuff.
Okay.
So he done had no rights already. Zero.
Like court documented no rights, or what?
I don't know.
Because if you have a child,
I
mean, you have.
But he can't just take the child without permission.
Well, if it's your child, right? That's what I'm trying to figure out. I'm talking about
He's a biological father, yes.
Okay.
But he didn't have.
But there's not a separation on like court custody.
No.
There's nothing
Well,
documented.
she got the attorney in.
I get that. They're working on it, but there's nothing currently in writing through the courts stating she has full custody.
Not to my knowledge.
Okay, I got you.
Her mother is having all that.
Okay, give me 1 second.
Okay.
3211 radio. 11, one black female undetained. Can you give me a beat check at 1925 Monroe Drive? Copy. Can you raise a, I copy that, never mind.
Radio.
Yeah, did you have a 26 on the next thing? I said straight around.
Okay, from 26. Pull it in, Joe.
You want to roll down the window? All right, ma'am. Ma'am.
Bring his ass, come back now. You're talking to just me. You're talking to just me.
Topic where you're around to a Hispanic male customer raised in the clerk at the location.
Yes, it's just me. It is just me. Bring my son back. I don't give a fuck if it's permanent or not. Bring my son back. I don't give a fuck what you gotta say. You took him out my permission. I don't have my phone. It's at the house. I don't have it. Why do I need to unblock you? My uncle can send you his location. You're calling him on his phone. I don't have shit to say to you, but bring my fucking son back or I will kill you. You have one or two options. Bring him back or you end up 6 feet under. Whichever one you want to go with. Yes, the fuck I want to do that. Yeah, I don't give a fuck about none of that. They have me in fucking handcuffs because of you. Because of you.
For 39 at 2415 Camellia Lane. Hey man, I'm talking, what was the pulling on at 4480 Fisher Hill? That was close off. Happy birthday. Copy last for 1218 1218. You said 2450 Camilla Lane? No. Okay, I got it.
Is she off the phone now? Okay, I need to know what happened from start to finish. We were chilling at his apartment.
Yes, sir. And me and him went in the room and talked about, I'm sorry, the sun's in my face. That's my.
You said, boy, you're the dad?
Yeah, me
Okay.
and my son's father, we went to talk and everything, and I explained to him the same thing I've been explaining to him since we moved to Florida.
Okay.
Come see your son consistently enough times in a row so he knows you.
Right.
And then you can take him because I don't know how he is around you. I don't know how you are around him. He has never been around him. It's
and plus it's too young for a baby to go without their mom.
Okay.
He doesn't understand that. He's only concerned about what he wants. I keep saying.
Well, I get all that, and then we started talking to him, and then
We was at a bar for, it was about 10 minutes had passed, and then his sister, me and his sister get into it because she asked her a question about my son, and like, no offense, but like, she hasn't been around my son enough, so she couldn't answer the question.
Okay.
So I answered it for her. Her sister got bucked with me. I'm like,
what
okay,
does that
but
mean?
like, got confrontational, like trying to fight, and I have messages of her constantly threatening me as well.
Okay.
So
Then how did the child get in their car?
Naquan took him.
The dad?
Yes.
Okay. Put the child in his car.
Yes, because they are trying to separate me and his sister, and I guess he acted like he was gonna talk to his sister. Supposedly, I'm not gonna believe it till my son is in my arms. He is 6 feet under. But he walked outside with her to try, I guess, calm her down. Next thing I know, my uncle's trying to get the baby to come back in, and then
Your uncle?
Yeah.
Okay.
And then he tells me, go get your baby, go get your baby. I'm like, wait, what? What? Yeah, so I was like, okay. So I went to the elevator. He yanked me in the elevator closed.
Okay.
And next thing I know, I'm getting set up. His brother pulls up with the car, and then his sister's in the elevator with me, still trying to be confrontational. And then next thing I know, they're pushing Naquan out the door. They, like, Gene pushed my son's head. I don't know if he noticed it, but he pushed my son's head trying to get Naquan out the door. And it's like, y'all are doing all of this with this baby in this boy's hand. I was aiming at everybody but Naquan because my son was in Naquan's hands.
What do you mean aiming?
Like, trying to get them, like, yo, y'all not taking my son. Like, I wasn't
How old
going
is
down
your
without a fight. 5 months. He'll be 6 months on Thanksgiving.
Okay. And then they got in the car and they drove off, and then we got in this car.
No,
we got
I
in a stranger's
complete stranger's car.
and came here.
Yes.
They came here.
Yes. No, not Naquan and them, but
So why did we end up here?
because the other guy had to go, he dropped me off here.
Okay.
I can't help you no more.
But they kept going down Church Bridge.
As far as I know, yes.
Okay. I got you. All right, hang tight. We have any court order documentation showing that you have full custody of the child?
No, but there's a birth certificate. There's no.
I get that. Okay.
Yeah, there's no.
11 at radio. 11. If 12 is free, can you have him come this way? And can you raise 96 for just rate 96? Hey, can I give you a 20 real quick? I'm sorry, read advise. I'm on the phone right now. Okay, I got it. You have an ID? An ID?
Yes.
An ID?
My ID is at the house.
Okay.
Hold on, mommy, hold on.
What's your first name?
Victoria.
Can you spell that?
VICTORIA.
Okay, and your last name?
Is there any other relevant material here that hasn't already come into evidence that I need to see?
And what state do we have a driver's license or ID out of?
Okay. Is there another video that you want to show, or is that it?
I think that's sufficient, Your Honor.
What would you wanted me to see, Ms. Helen? Okay, I thought so. Thank you. Anything further from the officer?
The state does have any questions for the officer?
Judge.
Come on. You have something for the officer?
Officer Thurman, now that you've seen your body camera, did Victoria Powell offer you any documentation showing that she's the primary owner or her?
I do not recall that, Emma.
Judge, I'm sorry. I'm sorry, Judge.
Oh, sorry.
Yeah, there's, and we got to get these mics back on.
It's not coming through clear.
I apologize, Judge. Can she hear me now?
I think we still have a reverberation for some reason. Does everyone have their mic back on or?
Yes, Judge.
Like, can somebody speak for me? Ms. Helen?
Yes, Your Honor.
Okay, is that better? Okay, thank you, ma'am. Go ahead, Ms. Helen.
And I'll just repeat just for the court reporter, Officer Thurman, did Victoria Powell offer you any proof of primary custody?
I do not recall.
That's it, Judge.
Okay. Can the officer be released?
Yes, Judge.
Okay, thank you, we appreciate it.
Thank you, sir.
Call your next witness.
Mr. Davis is not here. The state rests.
Okay. Ms. Helen?
Yes, Judge. Defendant calls the Quan Fitzgerald.
Okay, are you gonna have any other witnesses?
No, Judge.
Okay.
Please raise your right hand. You swear or affirm that the testimony about the case is the whole truth and the truth.
Yes.
Okay, you may lower your mask while you testify.
Okay. Is that okay if I keep it up?
You can put it down. Okay. You can leave it up, it's up to you.
All right.
Okay, so, when you testify, Mr. Cabral, let me just advise you, we have a right to remain silent. Anything you say can't be used against you. Because you chose to testify, you're gonna be subject to the cross-examination of the solicitor, in this matter. Have you gone, through with, your counsel, that you will be testifying?
Yes.
You will testify freely and voluntarily based on a conversation that you've had with your lawyer.
Correct.
The choose to do is to testify and be subject to cross-examination.
Yes, Your Honor.
Can you state your name for the record?
Federal.
I'm going to show you a piece of paper, okay?
And Your Honor, the state hasn't had the opportunity to see what the.
I have to authenticate it to him and then give it to the state, or I could give copy to the state now.
Well, let me see what he's looking at, so that.
Understood. Do you recognize what's on that piece of paper I just handed you?
Did you let counsel see?
Yes, sure, Judge. Actually,
Copy.
Well, Mr. Howland, we respectfully ask that we see what you have presented to the witness.
Yeah, we need to see what he's looking at to make sure
That's
the
the
same
thing. We'd just like to see what you presented to him so that we can see where it is. Thank you.
That's her,
it should be. Do you recognize what's on the piece of paper?
Yes.
What do you see on the piece of paper?
This is a portion of the conversation I had with Giovanni's mother back in 2019 about me coming to get him and spending that parental time with him. So this is just a few messages in a conversation where she agreed.
And try to talk it to the mic for me, okay?
Okay.
Is that picture a true and fair and accurate representation of the conversation that you were having between Miss Victoria Powell?
Absolutely.
I already gave a copy to the state judge. Did Victoria Powell give you permission to have GP?
Yes.
When did she give you permission?
The dates we spoke about.
Your
were-
Honor, who, sorry. I'm not, I think she has. Sorry.
Go ahead. Oh, thank you, Judge. When did she give you permission?
The dates we spoke about, I believe, were from November 22nd, maybe, to the 26th. One thing I do like definitely remember was she was okay with me having him as long as I returned him before the 27th, November 27th, 2019.
And Judge, I'm going to give state, I believe you have that exhibit C in that set. Yeah. I'm going to show you another picture, okay? Do you recognize that picture?
Yes.
What is that a picture of?
This is a picture of the confirmation of the actual dates. And I'm sorry, I said November 22nd earlier. We originally discussed me having him from November 9th, 2019, up until November 26th, as long as he was back before November 27th, 2019.
Exhibit D, I think you got a copy of it. Can
you show me, please?
Yeah, this one.
Can you show me that? What's?
Oh, sure.
Thank you.
Let me hand you another picture. Do you recognize that picture?
Yes.
What is that a picture of?
This is the original form we filled out at what was it, Gwinnett Medical, Lawrenceville at the time, which is now Northside Hospital. But this is the original form for Giovanni's birth certificate, in which I filled out. And it shows here it's dated May 30th, 2019. So 2 days after Giovanni was born, the form was filled out on my end.
So you did fill out the birth certificate.
Yes, the form was filled out on my end.
What happened to that copy?
I'm not even sure.
To your knowledge, in August of 2022, did Victoria Powell try to come to the Fulton County court system to get this case dismissed, or she told the court she didn't want to continue prosecuting this case against you?
It was in 2022. If I believe correctly, it may have been May 17th or 18th, well before August. So I think back in last May, there was a hearing I had in this very courtroom, and she did testify that she wanted to drop the charges.
Have you made any violent contact towards Ms. Powell?
No.
Any violent contact towards GP?
No.
And I think I'm going to show you one more picture, okay? Actually, I'm showing him.
You're not admitting these, correct?
Hmm?
You have not admitted these, correct?
No. I'm going to show you another picture, okay? You recognize that picture?
Yes.
What's on that piece of paper?
The confirmation of when I can have them.
And that's a true and fair and accurate representation of those messages between you and Victoria Powell, November 24th, 2019?
Yes, this is her, I guess it was a backup Instagram account, because we had disagreements like you've seen in the video. She said I was blocked, so I wasn't able to call her or text her through her phone number. Her original Instagram, I was blocked. I wasn't able to video chat or text her on that. So this is a backup account, or a fake Instagram account, however she used it. This is what she used to contact me, and this is the line of conversation that we had with her on this account. So,
Has Victoria Powell ever threatened you with violence?
yes.
When you were being contacted, was she threatening you with violence in those communications?
Yes.
Who arrived at the Lawrenceville location to retrieve GP?
I believe it was Atlanta Police Department, if I'm not mistaken. I really don't remember any names. I just kind of remember the uniforms. They had like olive green uniforms, kind of, sort of. So they were officers that I haven't seen before, but if I had to assume, I would think they were from Atlanta because that's where the incident took place.
Currently, where do you live?
In Snellville, 3281, Terry Ashley Lane.
And on the date in question, were you headed towards that location?
Yes,
Were you trying to enjoy some parenting time that you had already been given permission for with GP?
yes.
That's the end of my question, Judge. Do I need to present those pictures to you, Judge? I can bring that stack to.
And Your Honor. And the state would be objecting to if the defense is attempted to tender this, they haven't. Okay.
And Judge, I would like to consider those into evidence.
And Your Honor, we would object that they haven't established a proper foundation to add. We don't know what date and in fact who this person is that the defendant was talking to, and also hearsay and relevance.
Overruled on relevance, hearsay is overruled on foundation, it's sustained on, if you want to establish a foundation, Ms. Helen, I'll give you that opportunity.
Sure, Judge. I'm gonna show you another picture. Do you recognize that picture?
Yes.
What's the Instagram account listed at the top?
Says Tina, spelled Y-E-A-A.
Objection, we haven't seen what the defendant is looking at right now. We don't know what exhibit it is. There's so many.
Did you miss defense exhibit B?
Okay.
Why don't you label them as?
I have them.
So they just-
Okay.
Okay, so just have a look.
Okay.
Well, irrespective, Your Honor, she has exhibit B here. I have exhibit C. So I would still need to see.
That's a different one. So that's
a different, you see.
They're the same copy.
We would just respectfully like to see what the exhibit that you
Sure.
actually present to the witness counsel.
It's a.
Thank you.
So it's. And we'll mark it as exhibit A, Judge. I'll show you a picture. Do you recognize what's on that piece of paper?
Yes,
Do you recognize that Instagram account?
yes.
Who do you believe that Instagram account is associated with?
Victoria Powell.
And you believe that you're messaging Victoria Powell in this message here?
Absolutely.
And this messaging took place on November 2019?
Yes.
One more foundation, Judge.
Your Honor, there's no date, and I'm not sure how we can properly identify that this person he's talking to is in fact Mrs. Victoria Powell.
Judge, according to my client, that was Ms. Victoria Powell's previous Instagram account. These are screen captures taken in time to record the original conversation between him and Victoria Powell about the exchange of GP and how long he would be residing with my client in Georgia while Ms. Victoria Powell was visiting in November of 2019.
So is it true that there's no date that can be?
That's correct, Judge.
As to when these were sent?
There's no date on the screen capture, Judge, but speaking to my client, it's November 2019 that they had these messages exchanged between the judge.
An objection, Your Honor.
So I'm going to allow him to testify as to what date, but it is not on the actual, it's not on the actual photograph that they can be authentic. It doesn't seem to me, because he's testifying that this is Ms. Powell's email address, but there's no indication on the photo. He's testifying as to a date, but there's no indication on the photo.
He's testifying that this is her Instagram account, which also has a miniature photo, but that is her Instagram account with a smaller photo associated to the messages, Judge.
He's already testified as to what's on those photographs and what he recollects the date has been and who he recollects the date. I don't think a proper foundation has been made to get the thing done. So I'm going to sustain the charge.
Understood, Judge. Those are all my questions, Judge. No other questions.
Judge, sorry, you're not coming clear for some reason. I apologize.
Because I haven't turned my mic back on. I'm sorry. Can you hear me better now?
Yeah, 100.
Okay, sorry about that.
No, that's okay. I'm straight.
Hello, is your name, Procedural, correct?
Yes,
Okay. And, on November 24th, 2019, you did come to Mr. Keith Davis's home, correct?
yes.
And that was for the purposes of visiting your son, correct?
Say that one more time.
That was for the purposes of visiting your son, correct?
To have my parenting time.
And it was parenting time, meaning you came there to see your son, is that right?
Incorrect.
So what were you there for?
My parenting time.
What does that mean?
I'm Giovanni Powell's father. I was there to spend time with my son, whether I stayed there or not.
Okay, so, and you didn't have permission that day to take the child, isn't that right?
Incorrect.
So why did you leave without telling Mrs. Powell that you were leaving with the child?
She knew prior to me coming there. I only knew to come to that address because of Miss Powell.
Why did she chase after you guys had an agreement? You took the child?
She never said she had a disagreement with me. She said she had a disagreement with my sister.
But wouldn't you agree with me that if you had an agreement with somebody, they wouldn't be chasing about your child, you taking your child? It's
speculation.
No, you can answer the question.
Wouldn't you agree with me that if you had an agreement with Miss Powell about taking your child, she wouldn't be chasing after you or calling the police that day?
Would I agree with you? Personally, yes.
Okay. So when you took the child, you didn't have the car seat, correct?
Incorrect.
So the child wasn't on your lap?
No.
When you entered the vehicle?
No.
So what type of car seat did you have?
Not sure the brand. It was already strapped into the car with his diaper bag sitting in front of him.
What color was it?
Black.
It was a black. What type of diapers did you have that day?
They were Pampers.
The relevance is if he was there to take the child, then he's going to have diapers and a car seat for her. That's the relevance. So go ahead.
And did you have formula for the child?
I have formula, new bottles, bottle cleaners.
But the child was breastfed, so why would you have formula if he's breastfed?
I don't have breasts.
Exactly. So then, go ahead.
Does that mean my child doesn't eat?
So you knew your child, what? So you had formula, but your child is solely breastfed.
Incorrect. Did you not hear earlier when she said he drank a whole bottle down? It was formula.
The
Repetitive objection.
Miss Powell testified that he was solely breastfed.
Incorrect.
And, you said that, you testified to that you filled out a form for your birth certificate, that you, filled out a form with your information on the birth certificate.
Yes,
Where is that form?
I placed it in your client's hands and I haven't seen it since.
Why would you place it in her hands?
She's the mother. I had to work the day I filled it out. I had to go back to work. Her duty was to turn it in to the individual at the hospital after she filled out her portion, and we would be on a birth certificate collectively. I went to work that day.
Did you, legitimize your child at any point in time?
Can you say that one more time?
Did you legitimize your child at any point in time?
I've made multiple attempts. I haven't been able to do so solely.
Why, if you have interest in having custody of your child, why wouldn't you legitimize them?
I can't do it solely. I just explained.
That's something. Okay. And then you also stated that, you've never had violent contact with her.
No.
However, she was pushed out of the vehicle, was dragged out of the vehicle that day, correct?
She said I was in the car.
And was she also, you never had any violent contact with her at all?
No.
And one moment. So what size, you talked about having diapers with you, correct?
Yes.
What were those again?
Excuse me?
What type of diapers did you have?
I believe the brand was Pampers.
What size?
I don't remember. This was 4 years ago.
You don't remember what size your child had at that time?
Yes, I do remember what size. I can't call it off the top of my head what size I had in that bag. This was 4 years ago.
And you said you were there for parenting time?
Yes.
Had you seen the child, in October?
I'm not sure.
What about September?
I'm not sure.
What about August or July?
Yes.
You did see the child in August or July?
Yes.
2019?
Yes.
And then what form did you see, or the baby? Were you just, how did you see the baby?
What do you mean?
What type of visitation did you have with the baby?
Can you elaborate, please?
It's a very general question. Did you visit the baby?
Yes.
On the day of the incident, she drove all the way up here, right? From Florida.
I can't attest to that. I'm not sure what day she actually drove up here. I'm not sure it was the day of the incident. I'm not going to say yes or no.
But you seem to have communication with her based on your prior testimony, right? Good communication with her via social media.
I communicated with her through social media, yes.
So how would you not know whether she drove up that day of the incident if you had an agreement?
You can continue to ask your question. Go ahead.
Can you repeat the question, please?
How did you know How do you not know that she came from Florida if you had an agreement to take the child that day?
I know she came from Florida. You're asking me if she came from Florida the day of the incident, and I said, I don't know.
So now you do know that she came from Florida.
Yes,
Okay. And it's usually her coming to you to see the baby, correct?
incorrect.
When have you gone to Florida?
I've lived in Florida with her from May of 2022 until August of 2022. Your client didn't tell you that?
So you've lived with her from May to August 2022 in Florida?
Yes,
Do you have proof?
yes.
What's your proof?
My W-2 is coming from her job she claims she works at, Tortugas. We can call them. If you want to call them, we can call them. They have my social security number. I work there. We worked at the same job. I have a landlord who has my address changed from when I changed my address out here. I'm pretty sure it'll match hers with whatever address she had when she changed it. I'm pretty sure the addresses and the jobs will line up. Excuse me, Your Honor. I know I said May of 2022. It was actually April 26th of 2022 until August 26th of 2022.
So you said the last time that you saw the child was in August and July of 2019, correct? That was the prior testimony.
I didn't say that was the last time I seen him. You asked me if I seen him in those months. I said, I'm not sure. Then you asked about July and August. I said, yes.
So what exactly is it? Can you talk a little bit more about your time with Ms. Powell in 2022?
What do you want to know?
So how did you spend time with your child?
I would wake up, take him to daycare. Sometimes we'd be on and off. Sometimes she'd wake up, take him to daycare. Sometimes we both wake up, take him to daycare, go get breakfast after, come back home, take a nap, get up, go to work. Her mom, Giovanni's grandmother, would go and pick him up from daycare while we were at work. We would get off late, go to her mom's house, pick him up, head to where we live, and repeat the cycle until we don't work.
Okay, and what do you do with the, all I heard was daycare. What else did you do with the child?
We go out. I spend time with my child. I bond. If he needs anything, we go to the store. We go and get it. We take him out, let him have his social time with other kids. If there's an event going on in the city or something like that, his mom wants him to go to or anything like that, we'll do it. And
How old was your child in 2022?
how old was he? 3.
He was 3. He was born in 2019.
Yes, ma'am.
Okay. Do you have any pictures proving that you've been with your child?
This is my son and my daughter on Easter of 2022.
With you, sir?
With me.
And on those dates?
Yes. Should I unlock my phone?
So whether or not you had prior or contact with the child afterwards, you didn't have permission that day. On November 24th, 2019, you did not have permission to take your child.
Incorrect.
And so if you didn't have permission to take your child, why would Ms. Powell chase you?
I never said I didn't have permission.
I agree. He doesn't know why she chased him, if she did chase him. Next question.
That's all I have now.
Really?
No questions for me, Judge.
No? Okay. Closing?
Your Honor, can you stay have maybe like 10 minutes to do closing
10 minutes to do closing, or you need
Sure.
10 minutes to get it together?
to get together?
Okay,
Thank
all
you.
right, all right. There'll be a 10-minute break.
Your Honor, could you step out?
Hello?
I'm sorry, we did not have the court reporter on the record.
Oh,
Um,
no.
for the clerk. Forward.
I was here, I apologize, I just couldn't hear anything, and then finally I saw her moving, I said, I better let them know that I can't hear anything.
Did she hear mine?
Okay, so we do have it live on YouTube, and we can pull it from being live on YouTube if you need the transcript as we go forward. So we will continue at this point, Ms. Helen, with yours, and if we need the transcript, we'll get it from the YouTube feed.
Understood, Judge. From the video, Victoria Powell never states that she is physically assaulted by my client, Mr. Fitzgerald. She never states to the police at any time during this video, I watched the entire video, Judge, that my client forcibly took this baby from her. She states that she is in a verbal confrontation with the sister in the video. She tried to testify in court that it was physical, but on that date, she never mentioned any type of physical contact. And so, Your Honor, I do not believe, again, that the state can meet its burden and has not met its burden to prove that my client did not have permission from Victoria Powell. And not only can they not prove that he didn't have permission, they can't prove that he didn't have extended permission from Victoria Powell to then be able to have parenting time with GP Judge. That is why I ask, Your Honor, that you find my client, Mr. Fitzgerald, not guilty.
Yes.
If Your Honor, the state may respond. So a 16-5-45 interference with custody. A3 states lawful custody means the custody inherent in the natural parents, that custody awarded by proper authority as provided in Code Section 15-11-133. What does that state? 15-11-33 states whenever an order of disposition incorporates a reunification plan and the residence of the parent is not the county of the court, the jurisdiction or the residence of the parent changes to a county other than the county of the court with jurisdiction, the court may transfer the jurisdiction to juvenile court. Within 30 days of the filing of the transfer order, the transferring court shall provide the receiving court with certified copies of the adjudication order. So there's an order involved as far as lawful, but what does lawful custody mean? To add, Your Honor, the fact that the victim was irate, she had every right to be, her child was taken from her without her permission. Knowingly and recklessly, as I previously stated, what occurred. And the fact that she never states that he was physically assaulted by him, he's not being charged with battery or simple battery. He's being charged with interference of custody, so that's irrelevant. And the fact that we have proof that there was an extended permission. I mean, both parties here, Your Honor, did not act like they had an agreement. That's the whole point. He wouldn't have left with the baby in his arms and just without telling her and out the door, and she had to chase him. If they actually had an agreement, if somebody has an agreement, doesn't act in that manner. He knew what he was doing that day. He was taking the child without her permission. There was no such agreement on November 24th, 2019. And Your Honor, if the child is born out of wedlock in Georgia, only the mother will automatically be considered the legal parent. So with what I said in my previous closing, Your Honor, and what I've stated now, Your Honor, we are asking that you find this defendant guilty beyond a reasonable doubt for interfering with custody of Miss Victoria Powell. Nothing further.
Okay. Let me just say, I want to speak to counsel, both of you, after today, okay? I have a full page of questions, okay, that were not answered, and they were not answered because they were not asked. I can only make a decision based on what I know, and there were so many other questions that needed to be asked and fleshed out in this matter regarding this most serious matter. Most serious for the state, most serious for the defense. And I'm going to make a decision based on just what I know here. Let me first speak to Mr. Procedural and Ms. Powell. Y'all are young, but y'all are adults now. You have at least one child together. And regardless of what's going on between you two, that child's going to need his parents. That child's going to need parents that are stable, that are not fighting with each other, that are consistent in that child's life. I don't know if you have one child or two children together. I hear that, you know, that Mr. Procedural has at least 2 children based on some photographs. I don't know if those are with Ms. Powell or not. I didn't hear anything about that, but y'all have to get it together for this child. You know, I also heard that you've been in each other's lives after this for at least some period of time. You saying that, you know, that you're trying to get him legitimized, trying is not good enough. If you want to get that child legitimized to be your responsibility, you go do that. You get a lawyer, you go get them legitimized, and you start paying child support. Are you paying child support? I don't know. I didn't hear anything about that. If I didn't hear anything about it, I assume maybe that you're not. But if you're not, you need to be, if that's your child. All right, so I'm not happy with anybody in here. Let me just say, based on what I heard, you know, I think it did interfere with custody because all this wouldn't be going on in that manner. You know, you just don't take a child like that. You know, not only just for his mother's sake, for the child's sake. It's a 5-month-old child. Are you kidding me? Nobody does that to a 5-month-old child. You work your differences out for grown people. You have a child, that makes you grown. You have a responsibility. If there's nothing that infuriates me more than you all can do what you want to do, but this child can't do, your children can't. They're depending on you and on you. Has he spent any time in jail because of this?
Judge, I do believe, yes. I'll check the days of incarceration right now.
All right. So my ruling is going to be that I'm going to find you guilty of interference with custody. My sentence is going to be 12 months to serve, however many days he served, credit for time served, balance suspended. So it's going to be on the record that you have this charge, but I don't want you spending any more time as I'm going through this and thinking. I want you out there working and providing for those children. You understand me? And as for you, Ms. Powell, you know, you also need to get it together. You know, apparently you all were together for a period of time based on based on the uncontradicted evidence. And I don't know what happened, but you know, however you all get it together, you need to get it together for this child. Period. All right. Anything further?
No, Your Honor.
Okay. Anything further?
No, Your Honor.
All right. You all are dismissed, except for counsel.
Judge, may I be excused, or you want me to stay?
Oh, thank you. You're excused. Thank you so much. We appreciate it.
Ms. Helen.
And I do have some exhibits for you that we're going to have to get to you.
I'll be in for, this Taylor, I believe, tomorrow.
Okay. All right, so I have Ms. Bolton here with me, so Ms. Bolton will get you these exhibits.
Okay.
Okay, all right, thank you.
Your Honor, according to the jail screen, I don't know if Ms. Helen has responded. The jail screen shows it was 3 days. He was booked in on November the 25th of 2019, booked out on November 27th. For this charge of interference with custody, the jail credit him as having served 3 days.
Thank you.
Ms. Pereira.
Stephen, are you there?
Yeah, yes, sir. Yeah, yes, I am.
Was the recording, were you running the recording the whole time, or did you stop at some point?
No, I was running it the whole time.
Okay, thank you. So you're on the. So.
I'm sorry. That's okay.
Yeah.
Mr. Jordan. Saying that it was captured, it's saying that it's recorded.
Yeah, I know, yeah.
Okay.
We actually have a.
All right.
Yeah, but it had,